but I can follow what you're saying.
Okay, and maybe just I'm mumbling too much, so I'll try and avoid that. But Mr. Finlay.
Yes, so there was just I can hear you perfectly well, and I've been able to hear you perfectly well most of the morning. There was just one slight moment in your interaction with Mr. Trinick when your voice faded, that was all.
Okay, well, please raise your hand if there are any problems, or choose to interrupt if you want me to repeat anything. There's no problem with that.
The live stream is now working.
So are we live and ready to go, Graham?
Yes, the live stream is now up and running.
Okay, good morning, everyone. We have had a short delay for technical reasons, so that's why we haven't started at 10 o'clock for anyone watching the live broadcast of today's hearing session. My name is Keith Bray. I'm the reporter appointed by Scottish ministers to consider this application under Section 36 of the Electricity Act for the Glen Shiro wind farm. And I am to report back to ministers with my findings and recommendations. This hearing session today concerns itself with energy and planning policy matters, as well as economic benefits. I have a number of questions during the hearing session on these topics, and the broadcast is live on the DPA website. Tomorrow, I'll have further questions in a hearing on planning conditions and any legal agreements that may be required. In previous broadcasts, I've provided background and context for the public inquiry. On the opening day, that was Tuesday, the 10th of November, I gave an introduction to the application. And if you want to know more about the background, then please refer to that broadcast, because I won't do that today. However, there are a number of new faces around the virtual table today. And at this point, I would ask all the parties to introduce themselves. And I will start with the applicant, Mr. Trinick.
Thanks, good morning, everybody. My name is Marcus Trinick of Queen's Counsel, instructed by Nicola Martin and Wright Johnson Mackenzie. I'll introduce the team that we're going to be speaking today. Firstly, Jay Hambro, who is Chief Investment Officer of GFG Alliance and Chief Executive Officer of the Energy and Mining Businesses of Sinec. Secondly, Imran Abassi, who is the Power Business Development Manager of Sinec Energy. Thirdly, Julia Stoddart, who is the Chief Operating Officer of Jahama Estates. Fourthly, Graham Blackett, who speaks to economic and social matters. And fifthly, David Bell, who speaks to planning issues. Thanks, sir.
Thank you, Mr. Trinick. Mr. Finlay for the Council and Nature Scot.
Yes, so good morning, sir. My name is James Finlay, Queen's Counsel. I act, as you've indicated, for both the Highland Council and Nature Scot. And this morning, I'm also assisting the park in the presentation of the case to you, so that hopefully, and Nina Cowdery from the park is in the same room, suitably socially distanced, to assist a clear presentation of the three parties' cases which overlap in part. As well as Nina Cowdery, I have Simon Heinsohn, Debbie Green and Catherine Harry. In respect to the latter two, I'd hoped that we would had you would have received CVs by now, but due to a technical glitch you hadn't. So if I can introduce them slightly more fully. Debbie Green is an operations manager for Nature Scot in their South Highland area, has overseen responses to consenting authorities on development management proposals. She's worked for Nature Scot for 25 years with a focus on local delivery of the organisation's role in planning and protected areas for 14 years. Catherine Harry is a chartered member of the Landscape Institute and is an experienced landscape advisor for Nature Scot. She's worked over the past 16 years on the landscape and visual effects, proposed development and land use change in the Highlands and Islands of Scotland. Our responsibilities include advising on significant casework development plans and supplementary guidance based on a thorough knowledge of the landscapes of the Highlands and Islands. The bulk of her casework has been involved in advising on wind farms of varying scales, thereby developing a comprehensive understanding of their likelihood and the range of landscape. Importantly, for this purpose, she has led or contributed to Nature Scott's work on wild land since 2006, including the development of the national maps of the relative wildness and wildland areas, SNH technical guidance, assessing impact on wildland areas, and the description on wildland areas. And so, as you will be aware, but others who may have only tuned in today may not, Simon Brooks, for pressing personal reasons, is unavailable and is being replaced by Catherine Harry and Debbie Brooks.
Thank you, Mr. Finlay. Mr. Kelly, for John Muir Trust and Wildland Limited.
Thank you, sir. Good morning, everyone. Ian Kelly, Chartered Planner, representing the John Muir Trust and Wildland Limited. I have a short procedural point, which I think is possibly best taken after you've completed the introductions, sir, if that's acceptable.
Yes, I will be asking all parties if there are any procedural points. I have a number of intimations and points to make before we get into the hearing proper. Sorry, Mr. Gordon, I was on mute there. Would you like to introduce yourself?
Yeah, I'm Dave Gordon. I'm appearing for Mountaineering Scotland.
Mr. Kelly, did you catch the point that I will take your procedural matter once I go through other procedural issues as well? Did you hear that?
Yes, I did, sir.
Okay, I'll say a few words on how we'll go about things in the hearing on procedures, but I'm conscious that many people in the virtual room are very familiar on how we run hearings, so I'll try not to go on at length. The agenda has been circulated and then reissued yesterday. I just want to make sure that everyone has got a copy of that reissued agenda. Thumbs up, please, if possible. That's good. There weren't too many changes, but a couple of matters arose last week, so I have amended that. All the parties have had an opportunity to contribute to that agenda at a number of points through the process. It'll be a structured discussion around that agenda. I will lead the discussion. So there's no formal presentation of cases or cross-examination. I'll start off each agenda point by directing a question to one of the parties. And it may not always be to the same party, so I'll keep you on your toes. And I could be asking any of the parties. I'll likely ask other parties their views after I've heard the first point, but not always. But generally speaking, I will ask other parties their view unless it's absolutely clear. If you don't want to waste time by coming in on things, just put your hand up or thumbs up or shake your head that you don't need to contribute at any point. I may ask as a group if everyone's happy that we move on rather than going around each party. So if I do that, a simple thumbs up is all I need to move on to another point. My questions normally kick off a discussion, and that will generate other questions. If you have comments or questions as the discussion progresses, that's fine, but make sure they go through me and let each party finish off the points that they are making. Simply put your hand up or intervene that you want to ask a question through me. And one point is, even if you strongly disagree with what you're hearing, please let the other parties finish their point and don't interrupt until that point is made. I will leave it up to the leaders of the groups to determine who will answer questions. It's likely that I will defer to the team leaders in asking some of the questions, and it is really for the team leaders to then decide who will answer the questions. I think with regard to the technology, it may be helpful to our IT team if Mr. Trinnick can identify who will be answering any questions in order that the external camera is moved on to them. The team leaders may choose to make a couple of concluding remarks before we move on to the agenda or after answers from their parties. So please do that if the team leaders wish to add to what their team has said, then please do that. Hopefully you all have the electronic documents to hand, and if possible, refer to the core document number list, the electronic page if you can, if you're making references, and then the paragraph number. I will try to do that, but based on my notes, I might not be able to do it all the time. But please let me know if you're having difficulty following the documents. We've had a list of documents that may be referred to from a couple of the parties, so that's been useful, and people will have been able to load these up. So can I just check that everyone is content that they've got access to the core documents that were collated by the applicant? Everyone's thumbs up, so that's good. We may not be able to adopt as brisk a pace as would normally be the case in a hearing, but we'll try to keep things moving. If I feel that I've got enough for my report, or I've clarified the point I want to clarify, I will move on. So don't be obliged to repeat anything that's in your statements. I'm taking all of these statements into account when considering my report and what I hear today. All that you tell me today is evidence that I may need to take into account and include in my report. And you'll see me taking notes at times, and if I am taking notes, I might ask just for a short pause while I catch up. I have some procedural matters now in terms of process, but before that, I would thank the Council, Nature Scott, and the applicant for putting together the statement of agreed matters, not just for the hearing sessions, but for the inquiry. That has been helpful and has allowed me to narrow matters down. Now, something that I haven't intimated, but a procedural matter, at the end of this particular hearing, I would plan to hold what you might call a wash-up session just to discuss procedural matters going forward. I propose to do that at the end of this particular hearing because not all the parties will be present tomorrow at the conditions hearing. So if the parties are content, I will pause at the end of this hearing and return then for a 10-minute session just to agree timetables for submissions or any written submissions that are outstanding. Is that okay for all the parties that we, at the end of this particular hearing, just discuss any matters going forward? Mr. Trinnick, I haven't seen your thumb. Are you quite content? I've seen your thumb now. Thank you. I've had from the council a short email with the errata from Mr. Dowell on his recognition. So thank you, Mr. Finlay, for organising that. Yesterday, the council had asked to submit additional figures with regard to the visibility of the Melgarve substation, which was a point raised in the inquiry last week. I'm raising that just now because all the parties are here. I plan to deal with that matter through written submissions. I'm not going to discuss it today because we've had emails very late and submissions from both sides. So I plan to ask for information and allow the parties to respond to that rather than dealing with very late correspondence. But I would ask Mr. Finlay and Mr. Trinnick, are you content that I will deal with that through additional written submissions. Mr. Finlay?
Yes, sir. And as far as I can see from the email exchanges, there isn't going to be any significant dispute. I hope not anyway, but yes, I'm very happy for you to deal with it that way.
Mr. Trinick, I think I saw your thumb, so I think you look content.
You saw my thumbs there before Mr. Finlay said anything. I think there will be some discussions to be had before the position is finalised, but I'm content with dealing with the written submissions.
Thank you. And we'll discuss the timetable for that in the wash-up session at the end. Now, Nature Scott, I think from the emails I've asked for a press article from the Lochaber News to be admitted as evidence. I would like to hear the parties' views on that. It's just come in. I don't know if all the parties have seen it. I know Mr. Kelly has made a comment on it. Whether it's of value for the evidence in the hearing, I would like to hear your views on it. So perhaps Mr. Finlay, first of all, you could clarify if you wish it to be admitted and the benefit for today's hearing. Mr. Finlay.
Yes, so we would. It has some relevance to the benefit session that you're going to take first. We only became aware of it, certainly within our team, yesterday. It may have been published late last week, so that explains its late arrival before the inquiry, and it does relate to matters of the wider group, the applicant's wider group, and its approach to electricity generation. I'll wait to hear whether it's disputed or not before I make my case further, but Mr. Trinick and I have had brief discussion about it last night.
Mr. Trinick.
Thanks, sir. Yes, definitely happy for telling we can deal with it.
Okay, thank you. Mr. Kelly, and don't propose to call any of the councillors to the hearing today, but do you have any additional matters that you wish to raise?
No additional matters. So it's for the councillor and yourself to decide where you wish to hear from Councillor Baxter. I only made the suggestion because I know him and I know that he's very well informed of local matters, but it's not a matter for my clients to make a proposal on.
Thank you, Mr. Kelly. We'll leave that for Mr. Finlay. So on that basis, there's no concerns with admitting that, and if there are questions of it later on, then so be it. Okay. Would the applicant be content with giving it a CD number at some point? Mr. Trinick, yeah.
So I'm having a lag time with my mute button. I apologise. Yes, we can do that.
That's fine. Okay, there were two decisions, the Philologo Reg 2 decisions that were part of the core disc, so that's been clarified. Core documents, CD 926 and 927. I think they've been mentioned in the emails since last week, but they're part of the evidence. The applicant has circulated a copy of core documents 1221 and 1222. They had been referred to these draft agreements on the core documents list, but as far as I'm aware, they were not circulated before. I don't know if the applicant wants to briefly introduce them. We will talk about them later on. I would imagine under item 7E and JI. But I would like to have a short discussion on whether or not the parties feel that if they are discussed, that they've had time to look at them and it's reasonable to discuss that today. But do you have any introductory remarks before I ask the parties that they're happy to discuss any matters relating to these documents? Mr. Trinick.
Yes, sir, thank you. These are the two unilateral undertakings, which are very much in draft. One offered by Johanna Estates relating to the application of net rental revenue from the development when operational. The second unilateral undertaking relates to the power purchase agreement to be entered into by SINIC. I won't go further and describe the content of that yet. I think the discussion of the substance of these documents it falls into two parts. One part relates to the benefits of the development, and that will be discussed today. The procedural element, i.e. whether or not we proceed by unilateral undertaking or otherwise, and the legalities relating to the unilateral undertakings, I think also falls into two parts. Part may be discussed tomorrow in the conditions and agreements section. I think following discussion with Mr. Finlay, any issues relating to the fit of the documents for Section 75 of the 1997 Act will be more usefully a matter of written exchanges and closing submissions. And my proposal there is that within the time you will specify after today, we will make our submissions on the fit of the documents for Section 75, enabling the Highland Council, Nature Scott, National Park, Mr. Gordon, Mr. Kelly, to incorporate views on that topic within their closing submissions, giving us the right to final reply. I think that's the best way to deal with it, rather than trying to debate the legalities of the documents in open session. In your hands with that, that's a suggestion. That's my introduction. Thank you.
Thank you for that, Mr. Kelly. Mr. Finlay.
Well, so I do just simply record that they've come in very late, but we had an explanation by email as to partial explanation as to why that is the case. That said, they primarily relate to Mr. Heinsohn's evidence, and he's happy to deal with them today as far as weight and materiality go. I have indicated to Mr. Trinick I do have submissions to make as to legality, as to whether they in fact even regulate the use of land and so come within Section 75, which, as Mr. Trinick reminded me, was amended as of yesterday, I think. Mr. Trinick has also sought to put in the case of Elsick at CD 957, about which we have no objection. And just so that you understand where we're coming from, if one looks at paragraphs 38 and 62 of Elsick, that's the line of argument that we're seeking to take. I'm not in a position to give you legal submissions, detailed legal submissions today because of their late production, but Mr. Trinick and I have discussed matters, and I'm quite content with his proposal that they're dealt with in closing submissions, provided that I have a right to reply to any points he makes on a matter of law, leaving to Mr. Trinick the ultimate final word on that issue. We don't contemplate that will add significantly to the timetable, if at all, so subject to your approval of that approach, then we, for all the parties that I'm purporting to represent today, we have no objection to its introduction at this stage and are able to deal with insofar as this afternoon or the session this morning is concerned.
Thank you, Mr. Finlay. Mr. Kelly.
Sir, having regard to the procedural point I still to make to you, we are likely to have very, very little comment on these documents, and any comment would be in relation to whether or not they control the use of land, and I'm perfectly happy to include that in the closing submission, giving Mr. Trinick, of course, the right of reply.
Dr. Gordon, I have a thumbs up from you, so you agree with what has been said. Thank you, Mr. Gordon. Well, as indicated, we are likely to consider them under item 7E and J, and it will likely be the materiality and the weight matters today. Whether we touch on matters tomorrow is another matter, and we'll discuss the timetable for any written submissions in due course. But there does seem to be agreement that that's the most appropriate method to deal with the matter. Mr. Finlay did indicate that the applicant has asked for the Elsick case to be added to the core documents. I don't have any concern with that. Do any of the other parties have any concern? I think Mr. Finlay has said he's happy, so that's core document 957 now included. It may well be by the end of the hearing we've actually added a few other core documents, because it may well be that I ask that documents that are referred to in evidence to be submitted. So we'll just keep an eye on that as we move through the hearings. The applicant last week had asked at the inquiry sessions that we take item 7 on the agenda first. So on the reissued agenda, I didn't juggle about with the numbers. I kept the numbers the same so that no one would get confused. But I do plan to take item 7 first after these preliminary matters are concluded. I just want to make sure that everyone is happy and content and understands that that's what we're planning to do. That's fine. Nods of heads and thumbs. That's good. We will take breaks as we have done last week. So please take a break or ask for a break, not just take a break, but ask for a break. If you need one, we will pause at appropriate points. But if there's any particular concerns, I know that Mr. Kelly may ask from time to time, and we'll accede to that. We plan to be here till around about 4 o'clock today. And it's likely today that we'll take an hour for lunch, but I'll ask you that around lunchtime. Please bear in mind all the government guidance on COVID-19 when you're conducting your business today, and ensure that any risk assessments that you have for any of the venues that you're located within are adhered to. If I see that government guidance on physical distancing isn't being adhered to, then I may choose to pause proceedings. But I'm sure everyone will adhere to the guidance. Mr. Kelly has indicated he has a procedural matter, so I'm going to ask Mr. Kelly to introduce that matter now. Mr. Kelly.
Thank you, sir. As already apparent, this is going to be quite a long and intense day. My clients reviewed the evidence to date over the weekend, and they also gave regard to your revised agenda. My instructions based on that are obviously to answer any questions that you put directly to me, but beyond that, my contributions are to be directed towards wildland policy issues. So, for example, I would not intend to take part in your preliminary consideration of all the items under all the agenda topics under item 7. So again, it's just simply to try and help proceedings today. My instructions are to focus on wildland policy issues and avoid commenting on anything else unless you specifically ask me, sir.
Thank you for that, Mr. Kelly. I would expect that if I do have any questions beyond wildland, that you are in a position to answer them, because I think I do have a number of questions. But I will bear in mind that going around the table, that I don't necessarily need to ask your view on other matters outside wildland, but I do have a number of questions. So you're not getting away totally free of questions outside wildland, Mr. Kelly. Have any of the parties got any additional points to make on procedural matters? Mr. Trinick? Happy? Mr. Finlay? Happy? And Mr. Gordon? We have a thumbs up there. Okay. I plan now, given that we have had 50 minutes approaching the hour, that I plan to take we'll go 9-minute pause. That will allow people to take a comfort break, and we'll start back with item 7 at 11 o'clock. Okay, everyone hear that? And yep, okay, 11 o'clock we'll return and get on to the hearing session proper. Thank you. Okay, that's 11 o'clock. I'm just going to make sure that I can see everyone that I need to see. Mr. Finlay has returned. Mr. Kelly and Mr. Gordon. Okay, so I'm going to proceed with item 7 on the agenda, which is economic benefits. Now, my agenda points are a guide for the issues that I want to discuss. But at the end of the topic, please don't leave any matters outstanding if you want to ask any further questions. So the first one may well be a very straightforward and quick matter. It's with regard to the potential energy benefits and carbon balance only. Just to clarify any dispute on these matters, they're summarised in a number of places. I think Mr. Bell's hearing statement, which is CD 12.4 in section 6.2, highlights installed capacity would be in order of 168 megawatts and sets out the carbon savings there. Now, these matters appear to be not in dispute, so I just want to double check as part of this hearing process that no party has any dispute over the potential carbon savings and the potential installed capacity. I don't think there is from the submissions, but there's a thumbs up from Mr. Gordon and Mr. Kelly and Mr. Finlay. So that's one question dispensed with. I just want to be clear that there's no dispute there. You're happy for us to move on, Mr. Trinick? Yeah. Okay. Item B then, that's focusing in on the estimated employment benefits with regard to construction and the operation of the proposal, not the wider benefits, which we'll come on to. These are referenced in supporting documents to the application in the hearing statement of Mr. Blackett and the Council's report on handling at paragraph 8.4 or 840, I think it is, and also in the statement of agreed matters. So I just want to be sure that although they are estimates, there is no significant dispute over those estimates. But I did want to ask Mr. Kelly first off on that matter, whether, I think you've mentioned in your hearing statement, I think that's CD 16.6. That's Mr. Kelly's hearing statement. I think it's e-page 15 and paragraph 44. You provide some commentary there in terms of the plausibility of those jobs figures. So my question to start off with is to you, Mr. Kelly. Do you feel that you have alternative evidence to suggest that these estimates are inaccurate, Mr. Kelly?
It's not a question, sir. Thank you, sir. It's not a question of submitting alternative evidence. I mean, I've just looked at the figures in relation to what's the general level of employment in renewable energy. And it's simply difficult to imagine what these number of people are doing on a single wind farm site. It's as simple as that.
Thank you, Mr. Kelly. Mr. Trinick, would you like to respond to that?
Thanks, sir. I'll ask Mr. Blackett to respond to that point.
Yes, the economic benefits are summarised in my hearing report, which is CD 12.5, and there's more detail on the method that was used to calculate those numbers, which would be CD 1.8. So, in particular, chapter 4 of that, electronic pages 11 and 12 set out the methodology. But perhaps I can maybe pick up the key point that addresses Mr. Kelly's point. That the central to the methodology is that these are based on what has happened in other wind farms that have already been developed. So we're not trying to imagine what might happen in a wind farm. We're basing it on other wind farms that have been developed. And in fact, we've also submitted another document that gives further evidence of that, and that would be the Scottish Renewables the material, which is CB 7.6. And what that does, it looks at a number of examples of the economic benefit of renewables in rural Scotland, and that includes a case study looking at the Great Glen area. Now, it's not, it's looking at, and I put it actually as from our wind farm. So again, it just shows that these are based on evidence of what's happened at other wind farms, and therefore we can be confident that they could be realised in this case.
Thank you, sir. That's all we will say.
Thank you. Mr. Finlay, do you have anything to add?
Yes, sir. I wonder if I could, nothing in dispute, but I have two matters in clarification that would assist, and it's really a question for Mr. Blackett. In both his inquiry report and the chapter in the EIA, he's given greater benefits for Scotland, and which would appear to include potential manufacture of the wind farm manufacturing facility. If I just give you the reference in the chapter 10, it's 10.4.8, page 15 of 28. And I understand that the benefits for Scotland include the towers being manufactured in Scotland. Later in that same chapter, 10.35, there's a reference to the possibility that the GFG Alliance might develop its own specialised manufacturing facility, which may be located on land adjacent to the Dalzell plant. That's 10.4.35. The two questions of clarification are just to whether there's any progress in that, because that EIAR is now some 4 or 5 years old, and there's no reference to it in Mr. Hambro's evidence, for instance. And secondly, the second question of clarification is, what is the likelihood of manufacture in Scotland, and whether that's changed since the environmental assessment was written? And I suppose what follows on from that is the third question, is whether there's a general Scotland benefit which doesn't include manufacture of the turbines. So I'm not questioning the figures, I just would like to have some clarity of the up-to-date position.
Mr. Trinick, on your team?
Thanks, sir. I'll ask Mr. Hambro to speak first, and then Mr. Blackett.
Thank you.
So within the Liberty Steel business, which is within the GFG Alliance, we have a full suite of manufacturing equipment located on our Clydebridge site. This equipment was acquired from a facility in South Wales and then moved to the Clydebridge site so it could take the steel plate that we are producing from Liberty Steel in DL. We have spent considerable time viewing the possibility of using this equipment to make the wind towers for the Glen Shirra site, and we are continuing the review of that. Government policy with regards to supporting offshore wind and not onshore wind has, as you would imagine, lessened the appetite to move that facility forward. So actually, the decision to advance Glen Shirra is critical to our investment appetite for investing in this facility. So I think probably the most pertinent thing I can say is, yes, we have the equipment to make wind towers located in Scotland and taking the only steel that is produced in Scotland at our DL site to make the wind towers. And part of our investment decision to actually implement that equipment will be led by the results of us moving forward with the Glen Shirra project.
Thank you. I think you want to supplement that. supplement the answer and answer the second point raised by Mr. Finlay.
Yes, so the assumption in the environmental assessment was that the wind tower manufacturing would take place in Scotland, and that could be either at the existing facility or at the new facility if GFP Alliance created one. The benefits at the Scottish level, around a third of the total benefits would be associated, or slightly less than that. Sorry, it's a quarter. A quarter of the Scottish benefits set out in the environmental assessment would be associated with manufacture, but a bigger the balance, therefore 3/4, is associated with other areas of impact.
Thanks, sir.
Thank you. So that final point you made clarified Mr. Finlay's point. Mr. Finlay was looking for whether or not there was a scenario of not manufacturing in Scotland, and you've said that you take a quarter off essentially your estimates for employment with regard to that. Mr. Finlay, do you have any further questions on those responses?
Not questions on those responses, but I will ask Mr. Heinsohn to comment on Mr. Hambro's new evidence as to his suggestion that Glenshire is critical to their investment appetite for production, and that's, I think, been made for the first time this morning. So I'll ask Mr. Heinsohn to comment on that.
Yes, thank you. It's useful to hear the statement from Mr. Hambro in relation to the appetite and the critical nature of the Glenshire project to the manufacture of onshore turbines, and Mr. Hambro's comment with regard to the government appetite for more offshore rather than onshore in his comments. As Mr. Finlay's alluded, this is the first that we've heard of this, and it may have implications for the weight that could be given to the economic benefits of the project individually and cumulatively across the Glenshire project and the rest of the GFG Alliance schemes, which we're going to come on to later in the agenda.
Okay, thank you for that point. Does Mr. Gordon or Mr. Kelly wish to contribute? No. Any? Oh, Mr. Kelly does. Yes. Sorry, Kelly. I thought that was a signal that you didn't want to contribute. Mr. Kelly.
Interesting discussion, sir, but I would just say that the figures I referred to in paragraph 44 of my hearing statement were the figures for the operational stage employment, not manufacturing.
Does the applicant wish to say anything particularly about the estimates on the operational estimates for employment in response to Mr. Kelly then?
Mr. Bracken, please.
It's just to repeat the methodology applies to the operational as well as the construction phase. So it is based on what has happened in other projects. Of course, not all of these posts will be based on site, it will be based off site as well as on site. And not all of them, it's full-time equivalent posts, yes, so therefore not all of them are full-time posts.
Okay, thank you. Mr. Kelly, actually, you'd indicated that in your statement that proposed job estimates should be addressed in a legal agreement. Is that a matter that you would say that ministers should pursue if they choose to consent this application? Mr. Kelly, is that a reasonable proposition to secure the estimated job numbers?
I think in the circumstances it is. No doubt you'll come on to it later, but the aluminium wheel factory project has been abandoned, as I understand it. I find the job numbers, and they are referred to as jobs, not full-time equivalent jobs, simply implausible in terms of employment at the operational stage of a single wind farm. So if they are to be given weight, then they should be required to be delivered through an agreement. But I accept that it's a matter for ministers to consider, having regard to your report.
Mr. Finlay, do you have any comment to make on that matter in terms of the points that Mr. Kelly's made?
Sir, it's not something that Highland Council would see.
And Mr. Trinick, any particular comment on Mr. Kelly's point?
Yes, there are two. Firstly, simply calling something implausible isn't evidence. We've seen no evidence from Mr. Kelly to counter that and Mr. Blackett. When we do, we'll respond to it. Secondly, the benefits which Mr. Blackett describes flow naturally and directly from the development and do not need to be secured by any kind of legal agreement. Thank you.
Okay, I think I can move off that particular question and move on to item C on the agenda, 7C, and that's with regard to the question of defining national importance of socioeconomic benefits. I think Mr. Blackett's approach to defining the national importance is set out in his hearing statement E29 for the page number, and I think in the sections 1019 to 1024. So a question for the applicant: is that your evidence on defining the national importance of benefits of a proposal contained in Mr. Blackett's hearing statement? Mr. Trinick.
Yes, sir, it is, although obviously supported by what Mr. Bell has to say in relation to national policy, which we'll tackle later. But for the purposes of this session, yes. I note that we're hamstrung in one way as an applicant by the fact that we see no evidence against what Mr. Blackett had to say in anything submitted to date. So we're certainly happy to respond to what anyone has to say, but we're at this stage pushing an open door.
Thank you, Mr. Trinick. Mr. Finlay, do your team agree that Mr. Blackett's approach to defining national importance is reasonable?
No, and Mr. Trinick's door is certainly not open. So firstly, I'm going to make some points and then I'll ask Mr. Hindson to add to it. Mr. Trinick may have overlooked our hearing statement at 4.1.14 and 15, where we referred to the approach of the reporter as respectively at Dalater and Caplik, which are both ministers' decisions. I won't repeat those because you have them in our hearing statement. The second point is until Mr. Blackett's hearing statement, he had never suggested in either Chapter 10 of the EIAR or CD 1.8 that these matters were of national importance or unique. And the only matter that I understand that has changed since then that he now relies upon is the current COVID crisis. So it's a matter for you, sir, whether you wish to ask him to explain what else has changed which justifies his apparent significant change in approach. To provide a, in our submission, to put it broadly, there is nothing in this application which can be relied upon to take this scheme out with that of a wind farm, which provides the benefits which Mr. Blackett has outlined, and we are haven't disputed, as is made clear in our report of handling and our statement of agreed matters. And to that extent, we rely on it, the approach by the reporters at the two decisions to which I've just referred, that there is nothing in this case which can be secured so as to take this matter out of the ordinary and to suggest that its benefits are of national importance. Indeed.
Mr. Finlay, just on that, I mean, I think we'll come on to that, but my question was whether or not you are of a view that the approach set out by Mr. Blackett in terms of defining nationally important impacts is reasonable. So not leading on to the other matters that you raised, but do you think that approach that has been adopted in terms of looking at the national performance framework and the Scottish Government's economic strategy and such like set out in Mr. Blackett's report is a reasonable approach to identifying and defining what a nationally important socio-economic benefit or set of benefits might be?
Well, so it's very difficult to give you a yes or no answer to that, because it's how those matters are applied in this instance. And I will, as I say, I will pass on to Mr. Hindson to deal with each of Mr. Blackett's pillars in a moment, and we'll may bear your point in mind. But the other factor that we consider may be relevant is the assessment of significance of materiality in the environmental impact assessment, which suggests that the end of, let me just get the reference for you, at the end of chapter 10, I believe, I'm struggling to find the reference, it may be in CD 1.8, that the economic impact is not material. Or significant, sorry, my apologies, not significant in EIA terms. So that is another factor that should be taken into account in the approach. And with that, I'll pass over to Mr. Hindson to deal with the three pillars.
In terms of the methodology employed by Mr. Blackett, he's highlighted three pillars. Pillar one being purpose and national objectives, sorry, national outcomes, and we agree with so matters in that as in relation to renewable energy developments. There will always be economic benefits to a development which will be important at a local and regional scale. And that can alter depending on the economics of that particular area. And it's not disputed that the economic benefits of the Glen Sherrow scheme will facilitate other proposals related to manufacturing and also other proposals on the estate. There's the potential that the sustainability of the proposal has been overplayed. Green energy, delivery of green energy through a wind farm does not necessarily mean sustainable development. But so we'll leave that to you to determine whether the proposal is sustainable development or not. And we agree that the contribution to the proposal can play to the aim of GFG Alliance's overarching aims to deliver net zero with regard to their project. But it is noted, and I'm sure we'll come on to this later, that alternative power purchase agreements could be sought rather than just with Glen Sherrow wind farm. While there are potential for indirect contributions, there's no clear evidence of why the wind farm is required to necessarily deliver these. However, it is noted from Ms. Stoddard's evidence that other projects on the estate could still come forward over a longer time scale. Therefore, you wouldn't get the benefits in that shorter term. In terms of Pillar 2, the Scottish Government actions on that one. The collaborative approach that's been taken is very much supported by the Highland Council. But again, not clear why the wind farms is important to this.
Sorry, Mr. Benson, I seem to be getting quite a lot of interference. I don't know if everyone else is getting that. I think by the looks of things we are. So I don't know if someone else has got a microphone on in your room, perhaps, but you might have to just wind back a little bit. I think maybe the last minute or so, I was, or maybe 30 seconds or so, I was missing it, and I think the other parties were as well. So maybe if you try again just now, and let's see how clear you are.
Yeah, no problem. Is that any better?
Yep.
Can you hear me? Yep. Okay, so where there is, so the last point I was just making is that while there is potential for, under Pillar 1, sorry, and while there is potential for the indirect contributions, there doesn't appear to be clear evidence of these and why the wind farm is required to deliver these benefits. But it is noted from Ms. Stoddard's evidence that other projects on the estate could still come forward, but the benefits would not be felt in the short term, but they would be felt in a longer time scale because it'd be relied on the estate's other income to deliver those. In relation to Pillar 2, which is titled Scottish Government Actions, it's agreed and that the collaborative approach is supported by Highland Council, but again, it's not immediately clear why the wind farm is so important to that. We feel that it is quite a leap to go from Scottish Government involvement in delivery group for the wider benefits of the GFG Alliance investments in the area to the wind farm itself in isolation being nationally important. And then in terms of Pillar 3, economic recovery and transformation, the green recovery post-COVID is certainly supported by the Highland Council, as are, subject to the detail, the promoted associated projects. However, other green routes to recovery are also supported, and it need not rely solely on onshore wind or indeed this particular project.
I could just finish off on that. Mr. Blackett refers to national importance. Under national importance, he refers to planning policy and SPP, which is clearly a relevant consideration. He refers to the National Performance Framework and the government's economic strategy and action plan.
I'm sorry, Mr. Finlay, you're coming in and out. I don't know if it's because you're turning your head away or if there is other interference, but you're coming in and out of audibility. So I'll
repeat that, so my apologies.
Yeah, I'm going to have to repeat that. That's better now, though.
Yeah, so he's referred to, in his chapter 10, he's referred to planning policy, which is clearly not disputed as being a relevant consideration. He's referred to the National Performance Framework and the government's economic strategy and action plan. There are also, there's no dispute that they could be relevant considerations. There's no definition, and I think it's agreed by Mr. Blackett, of national importance. So our dispute is not that those matters are immaterial, but that they certainly aren't there's nothing there that assists in defining national importance. It's primarily a matter of judgment. And we've in part covered our response to that already. So I think Mr. Blackett overstates the case but I didn't take him to be doing this, limiting those matters, consideration to those matters. And in our view, the judgments to which I've referred, and the comments that Mr. Heinsohn made, need to be taken into account in reaching a judgment on national importance.
Mr. Trinick, this is starting to take us into the next items, but would you like the opportunity to respond to any of the points made by Mr. Finlay before we move on to D?
Yes, sir, we would, and I'll be turning to other people in our team to help me, but I'll start by saying, no, of course we have to look at the material about Delta and about CAPIC, but those decisions did not address the question of the approach to what is of national importance, which is the issue that Mr. Blackett has tackled, which should be addressed. All that was found in Delta, on the basis of who knows what framework, was that the benefits claimed were not of national importance, and the same with CAPIC. So we're looking at a different point, I thought we were when you asked the question. In terms of, I think Mr. Spence says nothing to be secured, but we're talking about how it's to be secured in terms of the conditions of the agreement session. You asked though, and you came back to Mr. Finney and said, well, is the approach reasonable? And I'm not sure we've still got a response to that from Mr. Finley or his team, except to say that the factors listed by Mr. Blackett are material. We've set out our stall very clearly in the evidence to Mr. Blackett, but this is a reasonable way of finding what is of national importance. And I'm not sure we have an answer from any other party yet to say no, it's not and why. So I think that might be pushed a little bit further. In terms of driving back to what the EIR says, well, I'm sorry, that's history. We're dealing here with the evidence before the inquiry by Mr. Blackett. I'll ask you not to get sidetracked by what was said in the EIAR on the topic of significance. That's rather different. In terms of Pillar 1 and the alternative for a PPA, I'm going to ask Mr. Hambro now to address that specific point.
Thank you very much. I thought it was worth reminding the audience that as the Liberty Group and the Alvance Group, we are one of the largest consumers of electrical power in the country, as we are in various other countries. So we have significant experience in both generation and dealing with very long-term investments and power purchase agreements. And I say that because I think it's important to realize the importance of control of both generation and usage. So the smelter here in Loch Arbour is one of the largest consumers of power in the country. And having the ability to have a very substantial generator allied with it and to work for the benefit of the grid, really, in allowing those two facilities to operate together and comply with what the grid requires and offers us the ability to do in terms of the balancing mechanism is enormously helpful, not only for us, but also for National Grid. And I think that's an important point to note.
So, Harold, could you just address the question of alternative PPA? As I understand it, that there are material advantages to GFG in being able to enter into a PPA on your own terms.
Correct. One, to secure a price that suits our operations in the long term, to make sure that we can take long-term investment decisions like we're doing here in terms of doubling the capacity of the smelter. And two, in terms of actual aligning the PPA with the operation of the generation.
Thank you for that. So we then moved on to Pillar 2 and Pillar 3. And I'm going to ask Mr. Blackett now to give a response to, briefly, please, Mr. Blackett, to the points raised.
I guess one of the points raised was about what the current circumstances and the national performance framework, and relating that to the COVID situation. So there's two separate points to make about that. One is that the national performance framework, while it has existed for a number of years, has gained increased prominence as part of the economic recovery plan. And that's set out, for example, in the economic recovery plan, which is CD 6.26. This connected point is that the consequent negative economic impacts of COVID have not been evenly distributed across the country, and some areas have suffered more than others. And this area would be amongst the areas that have suffered the worst, if not the worst, in the whole of the UK. therefore the economic need is greater than would have been considered at the environmental impact assessment stage.
Thanks, sir. That's the.
Thank you. If I could just come back with a question on the last point about the evidence around what you were saying, perhaps was Lochaber was worst affected by recent events. I mean, is that evidence that you can point me to just now in any of the submissions? I'm sorry if I don't have my hands on that.
Thanks, Mr. Blackett again.
Yes, so that will be in my hearing statement, which is CD 12.5, and I will just find the paragraph. So in chapter 4, so electronic page 11, from paragraph 412 down to paragraph 416, I deal with that issue using the statistics published by HMRC on what's become known as furlough, the numbers of people on furlough as an indicator of the negative benefits. Across the Highland Council area as a whole, it was almost 40% of employees were on furlough. And obviously that will vary a bit across the Highland Council region, but it would be expected, given the higher proportion of employment in Lochaber associated with tourism, that Lochaber will be even worse than the Highland average.
Thanks, sir.
But in that you don't provide, or perhaps I'm wrong, how Highland sits or Lochaber sits in Scotland or in the UK. You mentioned 1/3 of employees. Is that the comparison there? Is it at the end of 415?
Yes, that is the comparator. Yeah, so it's 40%, approximately 40% in Highland, and just 1/3 in Scotland as a whole.
Okay, so 33% versus 39%. Okay. Mr. Finlay, I think you were looking to come in there.
Yes, so just to respond to Mr. Trinick's point, your question was, is there any national guidance on defining national importance? And then you refer to section 10 of Mr. Blackett's statement. I think it's agreed between the parties there is no national guidance. And if one turns to the section of Mr. Blackett's statement, which has the title defining national importance, which is just above paragraph 1019. He doesn't actually set out a definition of national importance. I'm not being critical of Mr. Blackett. What he does is set out a basis for assessing it, and then goes on to do it. He doesn't suggest it's a definition. He suggests he assesses it against some factors which we've agreed are relevant, but or are material, but we don't agree that that's the only approach, nor do we suggest that that's a definition of national importance. So no doubt we'll come on to his assessment under the next question in part, but that's why I took you to Mr. Blackett's initial statement that until I think this evidence, there's been no attempt by the applicants to define an approach to assessment. So perhaps not surprising that Highland Council have not responded until now.
Thank you, Mr. Finlay. I think that provides an answer for Mr. Trinick's point that he raised with regard to your position. I think I'm content to move on to item D, which is similar, but it's just to clarify, and I think I know the answer. But my understanding is that the applicant's position is it's the package of benefits that is to be considered of national importance. Can I just want to double check that with the applicant, that's the position, that it's the whole package of benefits that you consider contributes to its national importance, or is it individual elements? Mr. Trinnick.
My evidence is that the package of benefits as a whole should be considered to be of national importance. And also within that package, both the rural regeneration benefits and the industrial benefits could each be considered to be of national importance. And that's the case that's set out in Chapter 10 of CV 12.5.
Yes, that repeats what you've indicated. So your argument is that there are elements, individual elements, as you've just said and previously set out, that are considered to be of national importance.
Yes.
Okay. Does the council wish to comment on that before I move on to another slightly different question?
Well, just to note our disagreement with it, which I think is probably clear, but we note the way the applicant has put its case.
Okay, I mean, I think before we'll go on to consider the statements of whether it's overwhelming or not, maybe I just need to ask the question, and it relates to other points elsewhere in the agenda, but is the applicant saying that there is a need from a policy and planning policy perspective to consider a national socioeconomic test? Is that what you're saying with regard to the proposal as a whole, or is it that the proposal is acceptable in environmental terms, but it has national benefits as well? Is there a national socioeconomic impact test for this case? And I know it relates to other matters. It might relate to earlier items on the agenda, but are we clear that you're saying that we need to engage a test to the applicant? Sorry, that was a bit of a long question.
That's okay, so thank you. No, we're not saying that. Our case is that driving back to the principal environmental complexity proposal, you have to decide whether SPP paragraph 212 is engaged or not. Our primary evidence is that it is not engaged, and that WIN-2 does not need to be addressed because there are no significant adverse qualities on the national park as a whole. And that is the only test in analytical terms which could be engaged so as to bring national economic benefits into the equation. Our secondary position, if you decided against us on the application of WIN-2 on SPP 212, is that we have made our case that there are benefits of national importance as raised in SPP 212. Those benefits are articulated variously by Mr. Abbasi, Mr. Hambro, Julia Stoddard, by Mr. Blackett, and in terms of the policy level by Mr. Bell. And that's the way our case is structured.
Okay, I think that was useful just to hear that at this point, Mr. Trinnick. I just want to clarify, is that the council's understanding of the applicant's case, just to be clear?
Yes, that's how I understood the applicant's, or we understood the applicant's case to be, that national importance comes in under the second part of paragraph 212 of SPP. Our case is that you don't even get there because they fail on the first part of paragraph 212. But if one gets to the second part, then issues of national importance come in. They would also come in as a matter of material consideration. If a benefit reaches the scale of national importance, one would understand that it could carry more weight. So I don't believe there's any difference between the parties as to the relevance of matters being of national importance or otherwise. But I see Mr. Trinnick has his hand up.
Mr. Trinnick.
Thanks, sir. Now, Mr. Finley's reminded me quite rightly at one point there that although I answered your question, there's the need to present a national benefits case. Even if we didn't need to do so, we would put forward such benefits in the overall planning balance.
Okay, thank you for clarifying that. I don't see Mr. Kelly or Mr. Gordon. Are you looking to ask a question, answer my question on that point? Mr. Kelly, your finger up.
Thank you, sir. It was just picking up from a number of points that are made in terms of claims of national importance. I just want to ask a question of clarification. Is it the proposition of the applicants that this project, this package being of national importance, would appear in NPF 4 when it's published?
Well, I'm not sure the applicant has that foresight, but you may wish to offer a view, Mr. Trinick.
No, thank you. Mr. Bell will cover NPF 4 to the need to the extent required when we cover the policy session, but I'm sure we claim the materiality for as yet unpublished draft.
Okay, thank you. So we've clarified Mr. Trinick that hasn't got a secret copy of NPF 4 at his hand. Mr. Gordon, you don't have any particular points so far. I've got another couple of matters on item D, but is there anything that you would?
So I have one point which I apologise. I probably should have raised it before it moved on from 7D. But one of the elements that Mr. Blackett uses to illustrate national importance is the Lochaber Delivery Group, which is referred to in his CD 12.5 at paragraph 10.25 and following on from that. And it may slightly undermine the significance of that group if I note that it has not met since 2018. That was my only point, sir.
Sorry, I think I was on mute there, so I do apologise for that. Mr.
I was beginning to get a bit concerned.
Yeah, yes. I was talking away to myself there. Sorry about that. Mr. Finley, you had your hand up.
Yes, so it's just to pick up on Mr. Kelly's point, which I'm not sure can be so easily dismissed as Mr. Trinick sought to do so. And perhaps I can phrase it this way: is this project the type of project that Mr. Trinick or Mr. Blackett or Mr. Bell would expect to see referred to in NPF 4 when it comes out? Not whether it will be or not, because obviously they don't know that. But Mr. Kelly's point, as I understood it, was more, is this the scale of project that one would expect to see it referred to in NPF 4? And so it's really a matter of clarification. We can comment on the answer in due course. But I don't wish Mr. Kelly's point to be brushed aside in the way that it has been, because as I understand it, it goes to the sense of importance.
Mr. Trinick, the point on, is this a proposal which is one which is the nature of which could be contained in a future national planning framework?
Yes, I'm sorry, I thought I was brushing aside Mr. Kelly. I was simply addressing the question, do I know what's going to be in NPF 4? I don't, but on the other hand, Mr. Bell, CD 1220 has provided to the inquiry representation made on behalf of the GFG Alliance for NPF 4, and it's no secret, therefore, that the request has been made that the Lochaber site will be identified as a development of national importance. That will be dealt with in the policy session. But as to what actually appears in NPF4, well, my answer is the same. I don't know. But Mr. Bell can further address that, and I'm going to ask him to do so. Carry on, Mr. Bell.
Yes, CD1220 is the NPF4 submission submitted by GFG Alliance, and that relates to the proposal to be included within NPF4. Clearly don't have a response on that yet, but what it does do is set out the integrated nature of the industrial activity together with the rural regeneration and the energy catchment for these activities. And reference is made in it to the section 1.6 to the National Development Assessment criteria that the Scottish Government have set out, which really guides the eligibility of such proposals. And critically in that is the link to the earlier discussion of the national outcomes and the national performance framework. So the planning system in terms of the future in NPF4 is, as Mr. Blackett has set out, very much linked to the national performance framework and the various outcomes. And rather than go into it in detail now, what may be helpful is table 1 in that submission. It sets out the basis of the proposed national development with the various national development criteria set by government.
Thank you, Mr. Bell. I'll just ask, so with your permission, Mr. Hambro to come in and address the question of the Locala delivery group.
Mr. Trinett, just before we move on to that, I just would like to just get clarification from Mr. Bell. The role which this project that I'm reporting back on to ministers, the Glenshiro wind farm proposal, plays in that submission. I'm looking through table 1 just now, but could he take me to the key role that this project plays in that submission, please?
Yeah, I think it needs to be read as a whole to understand the integrated relationship of the energy use to the unique activities that are going on and the combination of the state regeneration. So what may be helpful is in terms of paragraph 1.5.9, where it refers to the renewable energy supply position and how that has historically been an important link to the industrial activities. And that will be, as a theme in terms of energy generation, important running through the future plans for what has been called downstream industrial activity at the smelter. So not simply the smelter itself, but additional added industrial activity that could take place.
Thank you, Mr. Bell. Sorry, I'm probably going to come back again. So that, are you clear that the submission made by a GFG Alliance does or doesn't single out this project as being part of their submission? I just want to be clear on that when I'm reporting to ministers.
No, I don't think it would be appropriate to do that. But what the key principle within the submission that you'll see when you read it in the round as a whole is that in terms of green metal production and green steel, green aluminium, linked to the carbon reduction aspirations, CN30 as it's termed in the document, linked it also to the estate regeneration need and opportunity that the wind farm could play in a very important role in that.
Thank you. Sorry for jumping in there, Mr. Trinett. You're going to pass on to another of your colleagues.
Mr. Hambro, please.
Sorry, I can't remember who it was who brought it up, but the reference to the Lock Harbour Delivery Group is a really helpful and important It actually met in this room and was chaired by Fergus Ewing, the Cabinet Secretary, and myself on behalf of Mr. Gupta, the principal of the GFG Alliance. We had some very helpful sessions talking about primarily the development of the alloy wheels plant here. And with the decline in that program because of Brexit and subsequently the pandemic, that delivery group hasn't met for a while. But I am pleased to report that we had a conversation with Mr. Ewing last week and indeed before that. And Mr. Ewing is very keen to restart those delivery group meetings, probably in a slightly refined form, because we obviously have a lot of programs which are highly significant, and we are very fortunate to be working with the Scottish Government's support to move those along. So yeah, no, the Lock Opportunity Group has been a real assistance for us.
Excellent.
Mr. Finlay, do you have any additional points before I ask a question on the overwhelming nature of these benefits?
No, so I can make comment on the content of CD 1220 in my closing submissions, but I note that Glen Sherrow wind farm doesn't appear to be specifically identified in it at all. The word Glen Sherrow comes up twice in the context of estates. And whilst there's some reference by implication, potentially, in our submission, well, I'll make my submissions in due course, but that's all I wish to say at this stage.
Thank you, Mr. Finlay. My next sort of matters are really with regard to the statements made on the overwhelming nature of the national impacts and whether that sits beside the kind of overriding terminology that is sometimes used. So I suppose it's really a question for the applicant to explain the conclusions around the overwhelming nature, because that appears to take it into a higher bracket almost. So maybe some discussion around that, Mr. Trunick.
Thanks, sir. I'll just kick off by referring back to Scottish Planning Policy, paragraph 212, which sets the WIN-2 test as being that any significant adverse effects on qualities are
surprising if it's overwhelming. Receive one reference in the EIL.
Mr. Finlay, I think you've got your. Thank you for that contribution, but I think you had your microphone on there, so that allowed us all to hear that. Mr. Trunick.
Well, pity, sir. No personal information. Yeah. Turning to SPP 212, the test is that benefits should clearly outweigh impacts. Those benefits may be social, environmental, or economic in nature. And with that, I turn to Mr. Ballard from BPS.
Yeah, this reference in the hearing statement. Can you hear me?
David, it doesn't work that way.
Can you hear me okay? Yes. The reference in my hearing statement to paragraph 7.4.6 is to the terminology that Mr. Blackett uses in terms of the position being overwhelming. I think from a planning perspective, it's not a specific term I use or indeed overriding. But what I've said is that there is a very strong basis for concluding, on the basis of what Mr. Blackett says, that the benefits would be of national importance. And I make the point that what Mr. Blackett is saying is not a fine balance of just getting over the line on that. But his view is that the case is overwhelming from his perspective. So what I would say is that from a planning perspective, that there is certainly clear blue water, if you like, or as Mr. Trinick has just put it, clearly outweighed would be the case. And that is the position, and that is the context of the use of overwhelming in my hearing statement.
Thank you for that, Mr. Bell. That's actually quite helpful. Mr. Finlay, do you have any points to make on Mr. Bell's response?
Well, yes, sir. As presaged in my supposedly off-record comment to Mr. Heinsohn, so it is surprising Highland Council considers that something that is considered overwhelming was not mentioned by Mr. Blackett at all in his earlier evidence, either in Chapter 10 of the EIAR or his standalone document, which I think is CD 1.8 or 9, and received only one minor reference in Mr. Bell's planning statement, which is CD 1.7. One can see that at 6.4.1, third bullet point. Neither of them suggested it was unique, nor is it, as far as I can see, and I may be corrected, stand to be corrected, there's no suggestion of uniqueness in the environmental assessment or in any of the accompanying documents, or of overwhelming importance, and one brief reference to it being of national importance. And so in our submission, Mr. Trinick earlier said that that was simply history, but it's not. It's a case being put in a completely different way, whereas the project is substantially the same, subject to the COVID issue having arisen. And Highland Council's view is that it is not of national importance, and certainly not of overwhelming importance, nor does it come close to clearly outweighing the disbenefits that the three parties who I'm speaking for today have identified.
Mr. Gordon, I see that you've got your microphone off. Were you wanting to contribute?
Oh, I'm sorry, sir. I had not realised that was the case.
Okay. Well, I had I think that is taking us on to the next question of the uniqueness of the development. And I think just now, given that we've been sitting for an hour, it would be an appropriate time to break. So that would lead to a conclusion that lunch is going to be somewhere around about 1 o'clock or before that. So I was going to propose that we break now, because we've been sitting for an hour. But Mr. Trinick, your microphone's off.
My only point, sir, there is a timing issue which is unavoidable, and that is that Mr. Hambro does need to be gone by 1, hence the request to do this session first. I think we will finish by 1, but at that point he has to go, and I do want him to contribute in this session. I apologise for that, but that's unavoidable.
Well, thank you for letting me know that, Mr. Trinick. Let's come back at 10 past. We'll just have a short break and come back at 10 past 12, and then we'll continue on with.
Can I say something, sir, at that point? You know the circumstances. I will need more than a short break just now. I'll need about 15 minutes. But what I'll do is I will leave the video feed on and the sound on, and I will still be in this room. And if any matter arises, I will hear it and can respond. So I would not ask that the whole event is interrupted for that period, sir.
Thank you, Mr. Kelly. I might return to you once we get to item G. I'm just looking at my notes, so that's just, if that might be helpful to you. Okay, so we'll just take a short break, and at 10 past, we'll return at 10 past 12. Thank you. Okay, I think that's 12:10 now, so I'll just wait for all the parties to magically reappear in front of me. Is Mr. Trinick and Mr. Hambro on their way? Sorry, we can't hear you, Mr. Bell. I'm afraid you're muted. Okay, I think we're all seated. Moving on to item E now. Now, this is really just around why the development is considered by the applicant to be unique, and why this particular wind farm is important to GFG Alliance. So this is agenda item 7E, and it's really for the applicant in the first instance to explain to me why, so I can explain to ministers why this particular proposal in particular is unique. And you may wish to touch on the other points that I've expanded upon in item E. Mr. Trinick.
Thanks, sir. Well, to a very large extent, the question that you're asking is the evidence is there in the hearing statement of Mr. Abbasi in particular, and we'll come on to the estate benefits through Julia Stoddart under separate item 7G. But I'm going to ask, in the first instance, Mr. Abbasi to just summarise what he said in his hearing statement. Then I will ask Mr. Hambro to add any comments that he has to make. Carry on, please, Mr. Abbasi.
Thank you, Mr. Trinick. So the uniqueness of this project stems from the broad range of benefits that it provides. Those benefits are have been set out in CD 12.6, paragraphs 5.4 to 5.6, and chapter 7 of Mr. Julia Stoddart's hearing statement. So essentially, transformative benefits to the Jemama Highland estate, and then the ability to improve economic resilience of the Lokaba industrial enterprises, plus benefits to wider GFG's industrial organization in Scotland, that comprising of the steelworks at Clydebridge and DL, and GFG's industrial establishments elsewhere in the UK. So the benefits to those comprise the complete set of benefits to economic benefits to those enterprises, in our view, make this development unique. It's also important to consider why the uniqueness from the perspective of who is sponsoring the wind farm. Most wind farms are sponsored by standalone developers, integrated utilities, or infrastructure investors. This wind farm is unique because it is being sponsored by a committed industrial operator in Scotland. GFG has invested £500 million since entering Scotland in 2016. We have plans to invest nearly £100 million in further at the Lokaba site to add an aluminium billet plant at Lokaba site, to double the liquid aluminum manufacturing capacity at Low Carbon site, to introduce a canned water project at the Low Carbon site. This is a significant project, and it will create 70 new jobs at Low Carbon. And the wind farm will be an important part of the ecosystem that the GFG has developed. It will strengthen that ecosystem by improving the economic resilience, the financial viability of GFG's businesses, by improving our capacity to invest in future growth, by giving us the capability to protect the jobs that we already have, and to create additional jobs going forward. So that's why we feel, in a nutshell, why this project is unique.
Mr. Hambro, would you like to add to that, and in particular deal with the role of managing energy costs as part of that strategy?
Of course, I'd be happy to. So in so doing, maybe I could talk a little bit about the GFG Alliance and the partnerships that exist between the two energy-intensive users, Liberty Steel and the Alvance Aluminium Group, together with Sonic Energy. So the reason that the GFG Alliance has created this partnership is that we are very conscious of the need to create a sustainable future for industry, and to do that in a responsible fashion that aligns with our CN30 carbon neutral 2030 target means that you have to control as much of the value chain of your business as possible. So we seek to be vertically integrated both up and down, whether we be mining iron ore or coal, produce steel, or taking that steel into a final form. And one key element of that supply chain is power. So whether we be building the Glen Shira wind farm here in Scotland, or planning to, or building Australia's largest solar farm in South Australia in a place called Whyalla, where we're going to make hydrogen, which will be the production for steel. It is really important for businesses like the smelter here in Low Carbon and the various other ones that have been mentioned this morning, that they control their own destiny, and in so doing, look to control as much of their power costs and the ability to use the levers that you have by the operation and maintenance of a facility like Glen Shira for power generation. We are a very substantial investor in Scotland. I think today we put in just over 500 million, and we have done so with the creation of jobs. We now employ 400 people in Scotland across 6 sites, and therefore I think everything we're doing is critical to national importance issue, and if I may say so, I think unique, because we are well supported by governments around the world, whether as I was saying in South Australia with both the regional government there and the federal government, or in Romania, where we've just done a partnership with the Romanian government to make steel using hydrogen and a natural gas reductant. Those projects are of equal importance to us as a group as the generation of power here in Glen Shira.
I just might have said to you, well, beginning to point this way, so I'm putting quite a low evidence, I guess, and asking you to deal with it first to complete the answer to your question, is, well, why don't we go and buy a PPA from someone else and achieve the same objectives?
Well, I think I've sort of addressed that earlier in one of my earlier statements about what we offer here in Low Carbon. I think the Low Carbon smelter is one of the biggest users of power in Scotland and indeed in the UK, has an amazing value to the grid. We are regular participants in the balancing mechanism, and we have the ability for short periods of time to turn down the power usage from the smelter. So that means that we can add in the huge amount of power that we generate here, 80 odd megawatts, into the grid on demand. That extra lever and usefulness of us being a very large user of power and a very large consumer of power will be heightened by the ability for us to operate the Glen Shira wind farm in the same vein.
And so if I could just finish off on the point myself, that for an energy-intensive user such as Locarno or such as the other sites in Scotland for steel or aluminium, the control of energy costs is absolutely vital. And I mean control of energy costs in the long term, not over a 12-month period. Being able to forecast energy costs over a long period is vitally important. And GFG is in a unique position here, being able to procure a PPA on terms which enable it to control long-term energy costs. It's not simply a question of going and buying a PPA in the market. You'll buy at whatever price the market will bear. Here, the GFG is able to control that price. It may suppress that price to some extent. This is not a regulated market. It can do what it wants. And by doing what it wants, it helps to ensure the future viability of Locarno, future investment in Locarno, future investment in Scotland. That is very important. Thank you.
Thank you, Mr. Trinick. Before I have any supplementaries, Mr. Finlay, was there anything there that you wanted to come back on?
So I'm going to ask Mr. Heinsohn to comment on uniqueness, if I can.
Mr. Heinsohn?
Yeah, so I think there are some elements of uniqueness to the project, the relationship with other with the industrial elements, but I don't believe that's unique just to this particular wind farm project, or even this renewable energy project itself. We could cite another one of the CIMEC proposals, the Maygen proposal. There's proposals to bring forward other facilities which will allow the capacity of the Maygen proposal to be utilised in full through I believe it's a data centre proposal to allow things like that to be brought forward. So I don't think it's unique in its in that aspect. Other renewable energy projects are brought forward to support industries. I note the points that have been raised with regard to energy cost, and I fully understand the need to control as much of the cost as part of getting best value there. And the points that were made earlier in the session related to the need for that cost to be secured in the long term. However, we do believe that there could still be purchase agreements taken forward. Appreciating that.
Could you perhaps take your microphone off, Mr. Finlay? We're getting a bit of an interference.
Yep. Is that better? Okay, I think we're off now.
I think if Mr. Finlay is still off mute, so if Mr. Finlay could mute himself. That might help you, Mr. Heinsohn. Carry on.
Yep. So just in terms of securing a power purchase agreement elsewhere, and the point made earlier about securing the long-term power purchase agreement, it may be possible. I'm not saying it is possible, but it may be possible that a power purchase agreement could be secured with another plant. And what was interesting, though, to hear in the answer that was just given, was the use of the smelter plant as essentially in a similar way to a pumped hydro storage scheme could be used. So it stores the power and releases the power, which does seem to have some uniqueness in relation to the relationship with the wind energy development, which we don't seem to have on other projects, certainly in Highland, or I'm not aware of any others in Scotland, though. But I'd be happy to be pointed towards them.
My supplementary question was really with regard to the site and why this particular site is required to make the whole package work. So why this particular site is so important to the project, and could the benefits that have been described be delivered at another site, perhaps in the Highland region? I mean, why this particular site? Mr. Chinnock.
Thanks, sir. First we will deal with that point directly to Mr. Bell. I can ask Mr. Rabasi to come in first, just to highlight the point about the length of the power purchase agreement.
Certainly. So in terms, there's been a point made about the fact that we have the ability to procure power through a different PPA with a different generator. And I think that's certainly a theoretical possibility. It would give our business environmental sustainability, but what it will not provide us is economic sustainability. For economic sustainability, the power will need to be provided at a price that confers an economic benefit on our businesses. And when we control generation, we'll be able to provide the price that benefits us through various ways. The first way is that we'll be able to structure the price at below wholesale market price. So for every £1 discount that we're able to incorporate in the PPA, the annual reduction in energy bill for our businesses will be £460,000 or £14 million over the lifetime of Net Zero project. Our expectation is that the minimum discount that we will provide through a corporate PPA to GFG enterprises will be 5% of the wholesale market price. Assuming 14 pounds per megawatt hour for the length of the project, that translates into nearly £1 million per annum or £28 million over the lifetime of the project. So these are very significant benefits that our businesses will be able to capture. The other aspect is that we'll be able to cap the energy price that our businesses will face. If you look at energy market consultants' reports, they project a steady increase in power price, expecting to rise from the 50 to 60 pounds per megawatt hour range over between 2020 and 2030, 2040, and higher, beyond. So we'll be able to fix that price over the long term, cap it over the long term for up to 25 years, and that benefit and the saving relative to wholesale market price will grow over time. We have model scenarios where the PPA price will be £10 per megawatt hour lower or higher even than the wholesale market price, and that translates into annual savings of £4.6 million for our benefits, for our businesses. So these are very significant, savings that we can realize.
Mr. Bell.
Yes, one of the other reasons why the site is unique in terms of the wider landholding is that the other estates, in terms of Mamore and Killiconnet, are largely covered by wildland, and there's also NSA coverage coming in Glencoe. And of course, the Mamore estate covers a lot of the Ben Nevis area. So in terms of the opportunity afforded by extensive Group 3 coverage on Glen Sherrow and the existing infrastructure that can be shared and offer up an extension in effect of a wind farm, there is a lot of planning characteristics that favour where the wind farm is sited.
Thank you for that. Before we move on, Mr. Finlay, any final points on my responses to the questions there?
No, sir. I can deal with matters. It's probably better to deal with matters in closing submission. I make it clear I don't accept the answers, but I can deal with those in closing submission.
Thank you, Mr. Finlay. Mr. Trinick, given that some of your personnel are may have to move on, I'm just wondering if there's any other items on the agenda that you would want to consider earlier rather than going on to item G just now. I mean,
we're content that we deal things in order now. It was the only section E, I think, where Mr. Hambro's direct involvement comes to an end, and I'm grateful to everybody for doing that in good time. No, thank you very much.
Okay, Mr. Trent, I just thought I would give you that opportunity there. Okay, if we move on to the matter of tourism impact.
Excuse me, sir, can I just 7F? Are you not dealing with that, or have I?
Oh, sorry, I was thank you. I was just about to say I don't need to. I had that in my notes, but it was just further up the screen. I don't think I need to ask that question now. That was more a reminder to make sure I've got clarity. Mr. Trinick has clarified it earlier on, and if we need to revisit it, we'll do that in the policy session. But thank you very much, Mr. Gordon, for flagging that up. So I'll not be asking any questions under F, and I'm straight on to G. So there appears, from my reading, that there's broad consensus that making judgments and estimates on the impact on tourism in the round is a difficult exercise, and I think that's quite clear from the hearing statements. However, I would just wish to have some discussion on the proposition of Dr. Gordon that ministers should consider that the impact on tourism is a consequence of the visual impact of a wind farm deterring tourists, which is put forward in Dr. Gordon's hearing statement, and also his paper, which is CD 17.6. So I think, Mr. Gordon, before I ask the applicant or any others, is there any additional matters that you would want to kind of point out before I ask the applicant's opinion on that proposition?
I don't think so, sir. I think my paper is, I hope, reasonably clear on the matter.
Mr. Trinick.
Thanks, sir. Turn to Mr. Blackett.
Okay, yes. Mr. Gordon's report does set out his opinion on tourism and a hypothesis that any tourism impacts would be related to visual impacts. However, there's no evidence that is the case. In fact, there's no evidence that wind farm development is harmful to tourism. And, sorry, not Mr. Gordon, Dr. Gordon has spent a huge amount of time researching this issue. And I think we can be confident if there was evidence that wind farm development was harmful to tourism, that Dr. Gordon would have found it.
Dr. Gordon, I'll give you the opportunity to...
Sorry, sir, I was just trying to confirm. I have a paper copy here and I didn't have the CD number on it. I would just refer you to CD 17.7. That is not opinion, that is evidence.
And Dr. Gordon, in that document, is there anything that you wish to particularly draw out for my attention?
Having been a scientist, I appear to be a great deal more cautious than Mr. Blackett in drawing my conclusions. However, on what limited evidence is available, it seems to me at least a realistic hypothesis, and I put it no more strongly, a realistic hypothesis that a wind farm in the wrong place impacts upon tourism. Many wind farms are not in the wrong places. Many wind farms will not impact upon tourism. But Mr. Blackett's research has never considered the context in which a wind farm is set. My research, as using largely evidence provided by Mr. Blackett and Mr. Bell in previous inquiries, is, as far as I'm aware, the only research that has actually looked at the landscape context of wind farms and asked whether that has an effect in terms of tourism-related employment. And the evidence on small numbers is that it does.
Thank you, Mr. Gordon. Mr. Finlay, do you or your team wish to provide any comment on a CD 7.7 in terms of that proposition? Is that a proposition that your clients accept or have got concerns about?
We don't wish to provide, or we're not in a position to provide evidence on that particular proposition, unless Mr. Heinsohn corrects me. Highland Council's position has been, because it's been involved in a number of these inquiries, that the consistent position of Scottish ministers has been that there is no such evidence, and that whilst a number of reporters have left open the possibility that there could be harm arising from wind farms, no evidence has been found, so that Highland Council does not consider it appropriate use of its resources to provide you with a detailed response to that issue, which is why it has not taken the point in its report of handling or subsequently.
Thank you for that, Mr. Finlay. And is there any final points before I move on, Mr. Trinick?
Yes, sir, Mr. Blackett, please. Okay, turning then to Dr. Gordon's document CD 17.7. In paragraph 3 on the first page, he suggests that reanalysis of that's big economics data shows construction of a wind farm in locally designated scenic areas and associated with decreased tourism-related employment. If I understand the document correctly, the basis of that would be the analysis set out in paragraphs 13 and 14 on the second page of that document. What Dr. Gordon is doing here is he's highlighted 3 examples of wind farms located within an area where there's some landscape designation, and making the point that tourism-related employment here has performed not as well as the Scottish average. So that the suggestion is that that's evidence that there could be some landscape-related effects. However, if we turn to page 4 of the document, which is Annex 1, there's a table there, which I think is taken from the Big Economics report, which I was there off and on. And we see a list of wind farms with tourism-related employment trends listed. And in the middle of that table, we can see the Scottish average, which is a 15% change. So the way to interpret this table is everything above that row would be areas where tourism employment had outperformed the Scottish average, and everything below that row would be examples of where they had underperformed. Now, the general conclusion that comes from that is that there's not a pattern related to wind farm development. But Dr. Gordon suggested because there are 3 wind farms that are in landscape designated areas below the Scottish average, that there must be something linked.
However, that would not account for the other 8 that are not, by definition, in landscape designated areas. And so that would suggest that if there is a pattern here, that it's something other than the farm development elsewhere. The general conclusion of our report, the bigger economic report, is that it can't be wind farm development. It's such a wide range of performance.
Thank you, Mr. Blackett. I'm going to give Dr. Gordon the opportunity to respond to that before we move on. Dr. Gordon.
The correct approach to a research study is that you set up a conceptual framework and then place the data within that framework. You don't look at the data and then try to explain it. And what I have done is to set up a conceptual framework as shown in paragraph 9, and then use the data to test that conceptual framework. The 3 wind farms that are in designated areas showed a negative effect. The ones overall that weren't in designated areas didn't show that effect. Now, the other approach would be to do detailed case studies and to look at what was happening in every wind farm area. For example, just to take the one at the top of the list, Loch Lookout showed a very positive change because they had an influx of workers building another wind farm next to it. You'd have to do much more detail to understand the reasons for below average change in tourism-related employment in every wind farm. But just to take 2 examples, Spurness is a repowering, Whiteley is an extension. That alone could explain why they're lower. I do not argue that tourism related employment will necessarily decrease in every wind farm. It's quite patently obvious it doesn't. And I don't argue that it doesn't decrease in every wind farm in locally designated areas. That would depend on the context of the wind farm, the specific landscape configuration. But I do argue that we should not simply dismiss the possibility of tourism impacts on the basis of really what is a very, very small overall body of evidence.
Okay, Dr. Gordon, thank you for that. I think I'm going to move on unless anyone else is putting their hand up. I don't think so. I'm going to move on now to item H, and that's really my question here is around, after considering all the evidence, will I be in a position to report to ministers on my understanding of the net economic impact of the project? It's not asking, I'm not asking whether a net economic impact appraisal has been carried out. I'm asking whether the parties believe there's enough evidence for me to come to a conclusion on that matter. So if I can ask the applicant in the first instance whether or not there is evidence that I can draw my conclusions and report to ministers on.
Yes, sir. I think you've got a very solid body of evidence, which comprises almost entirely evidence from the applicant, as opposed to contentions that they don't agree with their evidence, but without providing any alternative evidence. That's not correct. People must present their cases as they see fit, but the only evidence you have comes from us, and it is more than adequate. Thank you.
Mr. Finlay, does the council have a difficulty in drawing conclusions on net economic benefit?
The council doesn't, and primarily a matter for you. To respond to Mr. Trinick's point, the evidence on net economic benefit of what may or may not happen is almost uniquely within the applicant's gift, so that we are largely reliant on replying in the way that we have done so far, and will do so in our closing submissions. But to answer your question, we are not in a difficulty in making submissions in support of our case, which is at odds with Mr. Trinick's case.
In considering the proposal, did the council have a difficulty with regard to concluding on economic matters? From reading the statement of agreed matters, I don't think that's the case, but perhaps you can just clarify that for me, whether the council was able to draw its conclusions from the evidence at that time on the net economic impact.
Yes, the council was able to draw its conclusions at that time, and I would make the point, which I've made on a number of occasions, that the evidence, that the substantive evidence remains the same, but the way that it's being presented and packaged has significantly changed since that which the council considered. And since that which the council considered and the way that matters are now put before you. But that change doesn't make a difference in our ability to comment on.
Thank you, Mr. Phillip. Mr. Kelly, are you around? I just can't. You are, Mr. Kelly. Sorry if I had to scroll across my screen. Do you have any point to make on being able to draw conclusions on net economic benefit in my report to ministers?
Thank you, sir. I agree with the position set out by Mr. Finlay. The key word is net. And as far as I can see, the applicants, primarily through Mr. Blackett, have not provided information on the costings of the external environmental and economic adverse effects. If you are to genuinely report to ministers on net economic impact, then those environmental and economic externalities need to be accounted for. And as I'm sure as Mr. Blackett is aware, there are perfectly acceptable means of costing environmental effects. But it is for the applicants to try to present that information to you and for you to evaluate it. It's not for someone like Wildland Limited or John Muir Trust to embark on an economic impact assessment exercise. But the key word, which has been emphasized several times, is in paragraph 169, and it is net. Thank you.
Thank you for those points, Mr. Kelly. Does the applicant wish to respond to the points that Mr. Kelly has made, or indeed Mr. Finlay?
So only to say, if Mr. Kelly has a means of monetising environmental impacts, we'd be delighted to see it. These are all the evidence base on which we can comment. So I have no further comment on the topic.
Thank you, Mr. Trinick.
Sir, can I come back on that?
Yes.
I heard what Mr. Trinick's saying, but is Mr. Blackett saying that he knows of no means of costing environmental externalities as an economist?
Mr. Trinick, is Mr. Blackett willing to respond? Sorry, I never caught that, Mr. Trinick.
I'm handing over to Mr. Blackett.
Okay, thank you.
No, I'm not saying there's no way of looking at environmental externalities. It's just in terms of it's difficult to know without saying what Mr. Kelly means in terms of specifics. If he had set out some specifics, then I'd be able to respond to it.
Okay, thank you for that, Mr. Blackett. Well, I think that's
one final point, sir, that in terms of the point that Mr. Finlay makes, we did actually set out our stall in terms of the case we were going to make in our inquiry statement, i.e. prior to the hearing statements being drafted and sent in. We announced what we were going to say in our evidence at a very early stage. Thank you.
Thank you, Mr. Trinick. Now, I think we can move on. We're probably approaching lunchtime, but I would like to move on, if we can, to point I, and that's really the question of materiality and or weight to be given to community bodies being involved in shared ownership and the status of any memorandum of understanding. But before I turn to the applicant, I think, Mr. Kelly, in your statement, I think paragraph 25, page 8, you've indicated that Scottish ministers have recently confirmed matters that community benefit and community ownership proposals are not material considerations. I just wondered, is that a case or evidence that has been collated in the core document list, or is that an additional case?
I would have to check the core document list, sir. It was a letter from the Scottish ministers to Richard Lockhead, MSP, I think in January of this year, which was submitted as part of the conjoined Clashgower and Rothes 3 inquiries. If it has not been submitted as a core document, and if no one objected, I can, once we're finished, get that submitted to you. As I say, I've not had a chance to check whether it was ready before you, but it certainly comes from the conjoined Clashgower and Rothes 3 section 36 inquiry.
Mr. Trinick, are you aware if it's on the core document list?
So it's not in the core document list, but when you turn to me to address this issue, I know what the letter is, and I've even got a quotation from it. And I've no objection to the letter coming in, so as to provide context for what Mr. Kelly and I are saying.
Thank you, Mr. Trinick. I may well ask for that, but let's move on to your a view then on the materiality of a memorandum of understanding between community bodies as it currently stands in this case. I'd like to hear your views on that.
Certainly, so we're talking about a CD 115, which is the memorandum of understanding between the applicant and Lagan Community Council. And I'll also say that some of these points are going to cover implicit submissions, especially as far as segregated legal points, rather than try and deal with them comprehensively in a hearing session. So I'll make my points briefly and cover them in more detail later. The letter to which Mr. Kelly refers is that of January 2020 from Minister Paul Wheelhouse to Richard Lockhead, in which he says, he confirms that, and I quote, financial benefits arising to owners from ownership of any development is not a material consideration in determining the acceptability of the development in planning terms. I've got no difficulty with that statement, because we're not saying that it's benefits to the owners which are material. We are saying it's benefits to the community arising from profits generated as a result of their investment, which are material, because those profits will be reinvested in the area. Now, to give the legal context, this is not a proposal proceeding under the Town and Country Planning Act, proceeding under the Section 6 of the Electricity Act. Now, this is relevant for reasons which are articulated by the court. And I'll put this judgment is not before us, but with your permission, I'll refer to it and then put it in. This is the William Grant and Sons Distillers case. The case reference for those who want it is 2012 CSOH 98. In brief, what the court confirmed is that Schedule 9 provides a self-contained code for Section 36 applications, and that neither Section 25 of the Planning Act, the primacy of development plan provision, apply, nor, importantly, Section 37 of the WIN-270 Act, which provides for how planning applications should be determined, i.e. the immortal words having regard to the development plan and other material considerations. So that law is not engaged in this case. So the only constraints on materiality, so far as you and the nurses are concerned, are reasonableness, rationality, and the need to have regard to Schedule 9 requirements. Now, those are the only constraints on the Scottish nurses in deciding what is or is not a benefit, a material benefit. Issues of weight are, of course, for you once you've determined whether or not something is material. So I'll cover those points of closing submissions in detail. The remaining issue is one of deliverability, and I refer you to, I'm not going to go to it necessarily, but CD 115 sets out its own terms. It's a non-binding memorandum of understanding entered into by the applicant with Lagan Community Council to share 5% of the value of the Glen Shirra wind farm project at the time that the investment by Lagan Community Council is made. It's quite naturally and ordinarily subject to such a proposal not interfering and preventing financial close. You can't mortgage a project to that extent. But the model which has been set out has been set out before in other inquiries. It's becoming very on put forward for shared ownership arrangements, which, as you know, are encouraged by the government, regardless of material consideration. In summary, therefore, the benefits arising to the community from the proposed arrangement is material. Mr. Blackett addresses possible destinations for such investment or reinvestment of funds in CD 215, I think I moved on that one. No, 215 of paragraph 715. And further details of the MOU in paragraph 79 to 713 of his evidence. Thank you, sir. That's what I want to say.
Thank you, Mr. Trinick. Is there any issues around weight, given the status or where the negotiations are, and as you described, the non-binding nature and early nature of the memorandum of understanding? Is there any weighting matters that I need to consider with regard to what stage it's at in terms of reaching a conclusion?
Yes, so it'd be fair to say that issues of weight will be affected by the current status of the document. We're not offering to secure this by any kind of Section 75 obligation. I guess if you wish to seek that, we would consider that. We say that in good faith, the applicant has entered into an arrangement with a local representative body. It will honour its obligations under the memorandum of understanding. And I will deal more precisely with the question of weight and closing submissions.
Thank you, Mr. Trinick. Mr. Finlay, do you wish to respond to the questions or answers on this topic?
Yes, briefly, and then I'll ask Mr. Heinsohn to comment too. I should say I have no objection to Mr. Trinick introducing the William Grant case, which I'm very familiar with, having been involved in it. Secondly, I accept that we are not in the planning environment, we're in the Electricity Act environment. But in my submission, whilst one is primarily bound by considerations of reasonableness and rationality, the general principle that one cannot buy or sell consents, which lies at the heart of the concern here, and I don't use that in a pejorative sense, still applies to Electricity Act consents. One should not be able to buy or sell them. So that's the first point. The second point is that a non-binding agreement in terms of ascribing weight to it cannot rationally be given anything more than very limited weight, if any. With that, I'll pass on to Mr. Heinsohn to give Ireland's planning's view of such agreements.
In terms of shared ownership arrangements, paragraph 83 of SPP Core Document 4.1 recognises that in remote rural areas, community-owned energy can help to support and sustain fragile communities and should generally be supported. However, in relation to the Memorandum of Understanding that's presented, given the stage that it is at, there seems to be a large number of ifs, mays, and best endeavours set out in the non-binding agreement. And it's also unclear what level of funding the community body would be required to put into the project to secure their share of the wind farm as well. So further to those points, I think given the stage of the agreement, limited weight could be attached to it, but shared ownership is a material consideration.
Mr. Trunick, I saw your hand raised there.
I was maybe get back to Hamburg.
I didn't quite get that, but I assume you did.
I'm saying goodbye to Mr. Hamburg, so I wasn't putting up my hand.
Mr. Kelly, then, do you have any remarks on the answers that you've heard? Or my question?
Nothing further to add.
And Dr. Gordon? Nothing to add. Nothing to add. Okay. Well, it's 1 o'clock just now. Do we try and clear off all the economic matters before lunch? Does that sound sensible? I've got a thumbs up from Mr. Finlay, and no one has got their thumbs down, so we'll continue. And we may or may not, in item J, get into one of the documents submitted by the applicant recently in terms of the draft legal agreement. But my question is around the parties' views on the extent to which rental payments and their use should be taken into account by ministers. And does that change when there is an agreement in place to secure those benefits? So the first point is really how best to consider rental payments, lease payments, when ministers are considering this application. So if I could turn to the applicant in the first instance, and then I'll get the views of others. Mr. Trunick.
That's probably one for me, sir, rather than Julia Stoddard. We drive back here to SPP paragraph 212. If the need arises to consider Loop 2 and the question of national benefits of social, economic and environmental importance. We say that in the circumstances where that paragraph is engaged, the dedication of 100% of the net revenues of this project, the figure of £840,000 a year on a current basis, will deliver social, economic and environmental benefits of national importance, sufficient of themselves, never mind the aggregation that Mr. Blackett talked about earlier, of themselves, to tilt the balance in the event that that test is engaged. So I think our evidence is crystal clear on that point. Others may have other views.
Sorry, Mr. Finlay, I was turning to you, but I would have been silent. Do you have a response to that, to my question?
I think to respond to that, in order to take them into account, they need to be legally material, and there needs to be a degree of certainty that they will be provided. And in our submission, in no sense are they either certainty that they'll be provided, nor is the legal materiality test met with, because there's no securing them by reference to regulation or use of land. And in terms of para 212, again, I note how these matters were put in the environmental impact report. And I'd refer you to paragraph 10.4.29, for instance, where ideas are canvassed. And that no amount of repackaging can elevate these matters to the status that Mr. Trinick suggests. I'll turn to Mr. Heinsohn to see if he's got anything to add. He doesn't at this stage in answer to your particular question. So that's our response.
And Mr. Trinick, you've clarified that securing those benefits and the commitments may well be the subject of further submissions. So I don't know if we want to go into that just now. I've heard your view and Mr. Finlay's view, but are these benefits to be considered in the wider public interest, and which elements of those benefits are in the wider interest? Is it the employment impacts that have been calculated as a consequence of that investment? What am I to have regard to with regard to the wider public interest? Mr. Trinick.
Thanks, I turn to Julia Stoddard to deal with that.
Thank you. So the important thing to remember here with the estates, and the best document to look at is CD 1216, which is our vision brochure, and page 2, especially our strategy. The estate is managed in an holistic way. So that means that no single decision is taken in isolation. The benefits are both public and private at the same time, and that is the point of this new management strategy for the estate. Benefits should not be just public or just private. The point of GFG's strategy, and it does this across the world, is it delivers good for its area while also making decisions that make business sense for its business entities.
Sorry, Mr. Stoddard, do you have additional points?
No, sir, I don't think we do. I think that the answer is quite straightforward, as put by Julia Stoddard, which is that the public and private benefits are indivisible. That we deliver both as part of that package, as articulated in Julia Stoddard's hearing statement. Again, I mean, this topic sort of verges on legal closing submissions as well, obviously, and you'll hear doubtless from Mr. Finlay, you'll certainly hear from me on this more general topic in closing, and also from Mr. Kelly.
Mr. Kelly, do you have any comments to make on my question or the responses that you've heard?
Thank you, sir. Mr. Finlay has covered most of my points I wanted to make, so I would just re-emphasize the matter you raised in the second question of your paragraph, That is, how are these claimed benefits, if you regard them as material, to be secured, legally secured? And that was a concern of my clients. But beyond that, nothing else to add at this stage.
Mr. Trinnick.
I just add there, sir, that when I'm just telling other parties, Mr. Finney will be aware of this, that Section 34 of the Planning Act, Planning Scotland Act 2019, was brought into force earlier this week, is a direct relevance to how these benefits, these particular benefits, are to be secured, because they involve financial payments, and the Section 34 amends Section 75 of the Act so as to provide that an obligation may either deliver something which regulates, restricts the use of land, or, in the alternative, delivers financial benefits. I appreciate that, but it's of relevance to all parties to look at that new law which came into force earlier this week.
Thank you, Mr. Trinnick, and perhaps you or Mr. Finlay or others could remind me in the wash-up session just to be clear how we're going to deal with that matter, so that we capture an appropriate procedure for dealing with that, or whether we agree it's all to be dealt with in closing submissions. So just a note to not let me forget about that matter before we close. Okay, are there any other matters with regard to the economic benefits of the proposal that we haven't just quite captured in our discussion under item 7? Are there any questions really that the parties would wish to pose through myself? Mr. Finlay,
yes, sir.
You're first, I think.
So it's about certainty of delivery, and I have two issues to raise. One is if one turns to 10.4.36 of the environmental assessment, so that's CD 1.3, one sees a reference to the GFG Alliance has plans to invest £50 million in the next 4 years in what would appear to be hydro schemes. And my question to Ms. Stoddart is, how much progress has been made in that regard? That's the first point I wish to raise, and perhaps I'll let her deal with that one before I come on to the second.
Mr. Trinnick, are you happy there?
Debbie, I thought I'd bring you in. Debbie, I thought I'd bring you in.
You better pick up on Mr. Finlay.
Mr. Finlay's point, if you could please just repeat that point. We had some difficulty in hearing.
Could you repeat your question to Ms. Stoddart, please, Mr. Finlay?
Yes, it relates to paragraph 10.4.36 of the environmental assessment, which is CD 1.3, and it talks of the Alliance plans to invest £50 million over the next 4 years in what appears to be hydro schemes, and it was to inquire as to the progress. I think 4 years have elapsed since that was written, to inquire as to the progress as to that.
Mr. Trinnick, did you catch that clearly?
We're just leaving out the reference so we can actually read the point before we respond.
Do you want to repeat the reference just while Mr. Trinnick's looking for it, Mr. Finlay?
10.436, is that right?
Yes, my apologies. I should have given the electronic page. It's page 20 of 28, and it's 10.4.36.
Could you bear with me just a moment, sir? I just want to consult on that.
Okay, I've certainly had a chance to look through that.
I can deal with it, sir. We're going again back in history, and it is history. The evidence before you now is the evidence of Julia Stoddart. What happened at that time was before she arrived on the scene, and she simply cannot answer that question. I understand that various schemes are being explored, but I mean, if you want more information on precisely what's been taken forward, we can obtain it. But I emphasise that the evidence that we are presenting to this inquiry, we dive back into the entrails of the environmental statement if you want. But the evidence we are presenting to the inquiry is the evidence you have in the hearing statements before you. And Mr. Finley wants to make a point about that and those in submissions, fine, so will I. We have nothing to add on that point.
Mr. Finlay, you've had an answer to the question. I think if you had another point you wanted to raise.
I've heard what Mr. Trinick said about the question. Yes, I was going to ask I was going to ask about the general track record in terms of SNH's involvement with other schemes with the applicant, and ask Debbie Green to give her experience in that regard.
It's all very well, but if we're going to have new evidence coming out, which has not been brought before this inquiry, and ask us to make an instant response, that's not the way things should proceed in the hearing statement. So I think it's really cautious about emitting a statement which doesn't relate to any evidence given to date by Major Scott.
Well, you might have heard me trying to sort of intervene there, Mr. Trinick, just before you spoke. I was going to ask Mr. Finlay if what is to be said is contained within the hearing statements or anywhere else in the core documents. So that was going to be my question, which relates to Mr. Trinick's point about whether this is this new evidence that you want to submit.
Well, so no, it's not, because we are seeking to respond to Ms. Stoddart's evidence, and which is fresh evidence. Mr. Trinick has referred before to his case being set out in inquiry statements, which are CD 11.1 and a response at CD 11.6. Return to them if you wish, but there's very limited detail in them, so that it's just simply seeking to put in context the aspirations that vision and strategy, I think, were the words that Ms. Stoddart used, and the certainty of such aspirations, vision or strategy, being implemented, and and it's simply to give our response to to enable you to put what weight you will on those aspirations. So if it's new evidence because we're responding to Ms. Stoddart's evidence. Very difficult in inquiry in a hearing session to do it any other way.
I'm certainly happy to ask Ms. Stoddart a question on certainty and how do you see certainty being secured in what you've proposed, and do you see the proposals changing over time that are set out, and is it the generality of the totality of the investment that you are looking to secure, or is it the individual projects that are suggested at this moment in time that will be secured? So I'm quite happy to ask you a question about that certainty and how those matters will be secured, and that may to some extent deal with Mr. Finlay's matter. So Mr. Trinick, are you content that Ms. Stoddart answers my question?
Yes, we have to answer your question. It's a totally fair one. Ms. Stoddart, please.
Thank you. So the vision document is a vision document. It's a strategy, so it doesn't contain detail. That's not what those documents are for. They're to set out higher overarching ambitions of the organisation. In terms of certainty, I was recruited a year ago to deliver positive, effective change in the region of Wahab and Banna via releasing the potential of the assets which comprise Jahama Highland States. So my professional reputation and my personal reputation is on the line of delivery of that. And I'm making that point quite strongly because I am committed to delivering what is set out in that vision document. That is why I'm here. I was appointed specifically to do that. The totality of the investment is what's important here. The projects that are described in my evidence are illustrative. They're examples. They're things that I think we can achieve if we have funding to do so. But the commitment of Jahama Island States, the commitment of GFG is to spend that money in the region to affect sustainable development across the three pillars of sustainable development, so the economy, the society, communities, and the environment. Any project that I decide to deliver on the estate must tick those three boxes, some to a greater extent than others, inevitably, because that's the nature of estate management. But I don't know what else I can say to you other than that is the whole reason for my job. That's why I'm here.
Coupled with that, so is the unilateral undertaking to commit to the expenditure of the net revenue that will obviously deal with content developments we come to the session tomorrow. I'm not sure what we can say. The evidence of the study is very specific and very clear. You've heard this from her.
Thank you, Mr. Trinick. I just have one follow-up question. If some of the projects that are aligned to your vision just now don't happen to bear fruit or run into some issues that you have to divert your attention to something else, is it, I think, as Mr. Trinick has pointed out, is it the commitment to the investment of £840,000 per annum into the estate that is the matter that is being secured, and not necessarily the list of projects? I just want to be clear about that.
Over to Mr. Donald, please.
It is the investment in the estate, but the projects are illustrative. They're not exhaustive. They're examples that we use to give the inquiry flavour of what we were proposing. This is a 114,000 acre estate that comprises urban land, peri-urban land, and rural land. There is no shortage of projects to deliver regeneration across that landholding here. And so that £840,000 per annum, which is a conservative figure, by the way, for the initial years of the project, will be spent.
Mr. Finlay, do you wish to respond to the answers that Ms. Stoddart has given?
Only to point out that I understand her position, and I'm not questioning her professional integrity or her reputation, but they depend whether weight can be ascribed to them in the decision-making process. Depends upon the certainty with which they will come forward, and that will largely depend upon consideration of the unilateral undertaking and how certain and what weight you can give to its terms, both in terms of legally whether it's binding, and secondly the particular content of the document itself.
Okay, thank you, Mr. Finlay. Mr. Kelly or Dr. Gordon, do you have anything to add to this discussion? Because I think I've heard what I need with regard to the economic benefits section, but is there anything, Mr. Trinick, on your side, any questions that you thought may have been asked that you've got something on before we move on to other topics?
No, sir, thank you very much. It was a very thorough section. We've had an opportunity to say exactly what we want. Thank you. Okay.
I would propose then that I would give the opportunity for you all to have some lunch. And it's 1:25 past. I did indicate an hour. You might you might think that would take us too far into the afternoon. So I'm going to suggest a shorter lunch break. Mr. Kelly, is 35 minutes from your perspective? Is that okay?
Yeah, I'll manage that. I think my time inputs this afternoon are going to be limited. I mean, I've been sitting here for quite a long time now. I will need to be very careful this afternoon, and I'll take a short lunchtime, but I couldn't honestly see me going on much beyond 4:15 after that.
The plan is not to go on beyond that, Mr. Kelly, because we may overrun. So will everyone happy that we return back at 2 p.m.? Okay, so we'll see you all at 2 o'clock. Thank you. That is 2 o'clock. I just want to make sure that all the parties are ready to reconvene. Just a thumbs up is adequate. That's good. Mr. Kelly, Mr. Gordon, good.
So may I just make a comment that I do not think I have anything to materially contribute to the afternoon's business. And I'm quite content if you essentially ignore me and assume if I do have a comment, I shall in some way make myself known to you.
Thank you for that, Mr. Gordon. Okay, I just thought I would open up with my plans. I would like to be able to get through items 2 and 3 this afternoon at the very least. If that leaves 4, 5 and 6 for tomorrow morning, so be it. But I would like to get through items 2 and 3 this afternoon. And if we have to start a little bit earlier in the morning, we'll discuss that at the end as well. So that said, we're on item 2 now, and my first point is actually dealing with a matter raised by Mr. Kelly in his hearing statement. That's CD 16.6, page 19, paragraph 58. With reference to that, Mr. Kelly, it's with regard to the role of the development plan. Do you agree with the statement of agreed matters, which is CD 18.2, that the council and the applicant have agreed, paragraphs 5.1 to 5.3? So that's with regard to the status of the development plan and reference to Schedule 9. Do you agree that that's the case, Mr. Kelly? Because I think you put something slightly different in your hearing statement. Mr. Kelly, I think you've just muted yourself.
Sorry, my hearing statement was in effect shorthand. I'm happy to accept the longer explanation set out in the statement of agreed matters, and I think that reflects the discussion that took place between the parties in the earlier submissions on policy shortly after the first procedure meeting.
So you have no queries on 5.8, 5.1 to 3. So that's useful. No party has indicated that they believe that Schedule 9 introduces any development management tests. Mr. Kelly, you're not suggesting, or any of the other parties are not suggesting that there are tests with regard to Schedule 9 that you would regard as development management tests. Mr. Kelly first.
No, it doesn't introduce what you might call development management tests, but you have to remember that it's an act of some antiquity that was designed to deal with the privatization of the electricity industry and the consideration of the consenting of very, very large thermal power stations. It's not a set of particulars that was designed for the assessment of wind farms, but I agree, reading it as for its words, it does not introduce development management tests in terms of what you might say is section 169, paragraph 169 of SPP2.
Thank you, Mr. Well, perhaps I'll ask the applicant then, just how does an applicant demonstrate that they've had regard to the desirability of preserving natural beauty, because that's in the schedule, and how an applicant demonstrates what they can reasonably do to mitigate effects? Perhaps if I could ask the applicant how an applicant goes about demonstrating those matters.
Thanks, sir. So for most of this session, Mr. Bell will be doing the talking. Mr. Bell?
Yeah, thank you. Yes, in terms of Schedule 9, the information that is contained within the environmental statement addresses the topics referred to. Therefore, that has been responsibly covered by the applicant. In terms of the approach to mitigation, the applicant has done what it can reasonably do. Insofar as various design approaches were taken to the development set out in the EIA report, and then indeed more recently with regard to a number of turbines referred to in Mr. Welsh's evidence. And yes, our position is that the schedule line does not contain tests as such, and I've referred to the Fallaghan Rig Minister's decision where they made it clear how schedule line was to be approached. That's CD 9.26 and 9.27.
Thank you, Mr. Bell. Mr. Finlay, do you have anything to add with regard to my question or Mr. Bell's answer?
Just two short points. One is that whether wind farms are accepted or rejected on appeal or on review by ministers, it's quite common for ministers to accept that the applicant has complied with its duties under the Electricity Act, but nonetheless refuse or allow, as the case may be. But it's not really just reinforcing the point that they're not development tests by which were agreed. And secondly, Highland Council's position and Nature Scots is set out in paragraph 2.3 of the inquiry statement, that whether or not effectively the applicant has complied, the wind farm is still unacceptable. So I don't think there's any dispute between the parties on the approach, the outcome clearly, but not the approach.
Thank you, Mr. Finlay. I think I can move on unless anyone wants to add. I can move on to item B. Returning again to yourself, Mr. Kelly, what I plan to do is ask a number of questions rather than going through them and getting responses on them all. I'll ask you, Mr. Kelly, just a few questions that there may be short answers, and then after I've asked the series of questions, I will then return to the applicant and perhaps others. So if everyone's happy with that, I think it'll save a little bit of time going back and forward. So, Mr. Kelly, my first point is with regard to which energy policy Scottish ministers should have regard to with regard to this section 36 application. So I think I took from your hearing statement that UK energy policy and targets are the key matters, and Scottish ministers' policy is secondary. Are ministers to take their own energy policy and targets into account, Mr. Kelly?
My position is that Scottish ministers can't set energy policy. Energy policy is not a devolved matter. So the energy policy that applies is the UK energy policy. It's an important consideration, but equally important is the position of Scottish ministers, who are perfectly entitled to set out their own strategy, their own suggested approaches, and their own targets. But strictly in terms of the word energy policy comes from UK level.
Okay, thank you for that. As I said, I'll go through just a few questions and then return to everyone. In terms of need, I think in paragraph 22, maybe 24 of your hearing statement, you've mentioned that Scottish ministers ruled that the needs case, as you put it, was not a material planning consideration. I think at the Gordon Bush extension variation application, my question, preliminary question is, has that been submitted in evidence for this case? Apologies if it has, and it's on the list. But I was just querying whether it was on the section 9 of the core documents so that I can refer to it.
I had thought Gordon Bush was included. My apologies if it's not in that long list of decisions. Again, it's a matter of fact. If it's not there, as I say, I apologise, and we can submit it following today.
Mr. Trinick, are you aware if it's been submitted?
It's not, sir, but I'm familiar with the point, which was raised by Mr. Kelly in a previous inquiry. We can deal with the point without the need to refer to any documents.
Okay. Now the next matter is the points you make in paragraph 21, where you suggest overcapacity and no overarching need, and you refer to, I think, August figures. A quick question with regard to, are the August figures in the evidence? I think I see the March figures, which are 6.5, and you've referred to August figures. Can I just clarify again if the August figures have been submitted in the evidence?
I had thought that the August figures were, pardon me, one of the updates submitted by Miss Martin at one stage, but it's quite difficult to keep track of all the documentation that's flying in and back and forth. Again, I can submit them if it need be, but as I say, I had thought that was one of the updates that had been submitted at an earlier stage.
Is anyone else aware whether or not the August figures? I just looked through the core document list section 6, and I don't come across them.
No.
No. So, does any party have any issue if I ask for that at some point?
No, that's fine. I'm happy.
Okay. So, the substantive question to you, though, Mr. Kelly, is that you're saying that there is no overarching need, and how am I to consider that in reporting back to ministers? Because I think that's your point, that the figures suggest that there's no overarching need. What implications does that have for my report to ministers?
It affects your consideration of the planning balance. Can I say, first of all, on the need question and the Gordon Bush extension decision, the statement by ministers somewhat surprised me as a planner, because I thought the whole thing about renewable energy was to satisfy some sort of need in relation to Scottish Government's targets. Subsequent to the Gordon Bush decision, every time I've made a representation on a Section 36 wind farm, I've referred to that paragraph of the decision letter and invited a response from the Energy Consents Unit to say that the minister's statement was wrong or was misinterpreted, but no such response has ever been received. On the issue of the overcapacity and how you consider it, it's a straightforward land use planning point. We have an installed renewable energy capacity of 11.9 gigawatts. We have a pipeline of 13.5 gigawatts as of August. The Energy Consents Unit tell me they are getting 3 new inquiries for new schemes every week just now. Given predictions of demand for electricity in Scotland and in the UK, there must surely come a point where there's no need to consent and build out further capacity. I mean, do we not stop? Do we continue to consent schemes until every hill in Scotland is covered with wind farms? I mean, it's a simple land use planning point. There is a limit to the need for renewable energy. There has to be.
And your reference to pipeline there, Mr. Kelly, I think, is that defined? I think that's defined in the energy statistics, but I would just like to confirm that just now, because you mentioned pipeline. I think it's defined in the figures. See if I can get my. I think I assume the August figures as well also define pipeline.
Yes.
So are we all quite happy with the definition of pipeline as it is used in the because I assume that's the definition that you're using as it's described in the energy statistics. That sounded like a yes, but you just muted yourself. Sorry, mate. Or it looked like a yes. Sorry.
Yes, yes, it is.
Okay. Okay, that's fine. Right. And the final point, before I ask the applicant maybe to address all of these matters, is in terms of your comments on grid capacity and constraint payments. Again, how am I to consider your comments with regard to reporting to ministers? I think that's from paragraph 16 onwards in your hearing statement. How should grid capacity and matters relating to constraints payments be considered in the planning balance? Maybe that's a better question.
The constraints payments I regard as one of the economic externalities that should be addressed in a net economic impact assessment. The second point is that the constraints payments represent payments not to generate and transmit to the grid. So it is, if you like, lost benefit compared to the theoretical position. And thirdly, in this case, it impinges on the question of alternatives, because we have right next to this proposal a wind farm which is receiving which is receiving very, very significant payments not to generate electricity. And as Mr. Abbasi himself said, the alternative power purchase agreements from existing wind farms gives their business environmental sustainability. He wasn't so happy on the financial side, but he said it gave them environmental sustainability. So here, it's a reasonable proposition or question as to whether, looking at the constraints payments, it would be better overall in terms of sustainable development, given that Strathclyde is there for the smelter to take its power supply from the existing wind farm rather than have a new wind farm and thereby save consumers the cost of the constraints payments. So three aspects.
And are these matters that you consider to be relevant to the planning balance that I and the ministers will be required to consider?
Yes, I do.
Okay, well, what I'm going to do is ask the applicant. I know there's quite a number of points there, but if you wish to respond to the questions and in particular the answers that Mr. Kelly gave there. So, Mr. Trinick.
Thanks, Mr. Ballard. I will share this. I think the first point was about UK energy policy and Scottish energy policy. And Mr. Bell asked that first.
Yes, energy policy is reserved to the Westminster Parliament. And so the UK government retains overall control of energy policy, and there's no issue with that from our perspective. And although the energy policy is not a devolved matter, all the UK energy documents that have been set, and I'm going back to the route map for renewable energy of 2011, they've all made clear that the devolved administrations have an important role in attaining the overall UK and European and indeed international obligations on renewable energy. And while the Scottish Government does not have core competency over energy policy. They have nevertheless prepared route maps and energy strategies over successive governments, going right back to the last 20 years and more, untrammelled by Westminster and indeed encouraged by Westminster to set their own paths. And furthermore, the Scottish Government has sought to execute policy by way of planning decisions and planning policy. And that's very clear through SPP and NPF3. Also, I've made reference to the documents that have been lodged. One is the Committee on Climate Change progress report to the UK government, just submitted in October 2020, which is, sorry, that's June 2020, and that's CD 620. And we have the UK government's response to that, which is CD 6.31. Now, the UK government has just responded in that last document to say a key objective to attain net zero is the delivery of more renewables. And that's page 15 for your notes, sir. And the focus in that is the net zero position for the UK, and clearly Scotland will contribute to the UK net zero position by 2050, in addition to attaining its own net zero position by 2045. So that's really the answer to the first point on energy policy. So our position is that it is entirely relevant to take into account the Scottish Government policy position.
Sorry, I interrupted you. Moving on to the second point, which is paragraph 21, 23 of Mr. Kelly's statement. It takes us necessarily into paragraph 24. First of all, dealing with the Gordon Bush point, I've seen that November 19 determination, the last inquiry at which Mr. Kelly and I appeared. This was a section 36C application, therefore to vary section 36 consent. And in the explicit context of section 36C, the ministers determined that there was no requirement to demonstrate the need for the development because that need had been demonstrated on the original section 36 application. So these are very specific circumstances which don't apply here and are indeed quite irrelevant here. What Mr. Kelly then develops, I think, in 24 is to say, well, if the ministers decided need is not a material consideration, there's another case, the UK Supreme Court, I know the one is the Royston Dean case, is also not before the inquiry, which confirmed that such matters as community benefit were not material considerations. And he's saying, well, that case means that any ruling has to be consistent across all wind farms, and therefore need can't be relevant here. I think that's his broad point he makes, tell me if I'm wrong. But the fact is, need is a central part of the considerations which you need to report the ministers upon. There's not a section 36C application. Of course, needs relevant. There's no dispute about that at all. I don't know who Mr. Kelly is speaking to at the ECU. Would you really expect the civil service of the ECU to give their own comment on what the minister had said? I don't think so. In terms of the pipeline point which comes from that, I'll let Mr. Bell deal with that now, actually, before we go on to the third point. Mr. Bell, the pipeline point.
Yes, in terms of the pipeline, in my hearing statement, sorry, I've got a warning coming up on the laptop. In terms of the pipeline, I set out pipeline capacity on page 24 of my hearing statement, which shows that there is awaiting construction some 7.7 gigawatts of renewable capacity, and in the planning system another 4.1 gigawatts. Now, the Scottish Government has consistently said that significant weight cannot be placed on consented capacity because not all of it will be built for various reasons. And a good example of that is the tip height increases needed now for two developments that were consented a number of years ago that are simply uneconomic now. But the fundamental point beyond that pipeline is that what is needed has to be transformational. The Committee on Climate Change has set out very clearly the massive expansion of renewables that is needed. We'll perhaps come on to those references in the next few agenda items, but with all respect to Mr. Kelly, it would seem he has simply not read these documents, because it's there in black and white in terms of the significant additional capacity needed, in particular in terms of the net zero agenda that is now set in law. So we've always, I say, come on to that, but I think there's one way to perhaps shortcut it a fair bit on that, and that is the recent area decision by the Scottish ministers sets out their position, and that's CD 9.21. And it states in there at page 26 that renewable energy deployment remains a priority of the Scottish Government. This is a matter that should be afforded significant weight. And then on page 27, the government refers to the onshore wind policy statement, and they state that it reaffirms the vital role for onshore wind. The statement sets out the Scottish Government's position for the ongoing need for more onshore wind. So that was a decision of just this summer against that pipeline position Mr. Kelly has referred to. So I think, as I say, come on to more points shortly, but I hope these matters are helpful.
Thanks, thank you, Mr. Bell. The third point made by Mr. Kelly, paragraph 21, constraint payments. Mr. Bell will deal with those payments. I deal with two subsidiary points. Firstly, he encourages us to go and procure electricity through PPA and straight there. Well, there's a contractual law difficulty there that Strohnegg wind farmers generator has committed is that it goes via a PPA elsewhere. Can't go and pinch electricity from another wind farmer. It's committed by PPA elsewhere. And I, before handing to Mr. Bell, refer to what Mr. Hambro said this morning, that of course at a more local level, the high energy use of the carbon can be managed in a way so as to provide a useful balancing mechanism which is of value to the grid. And that has to be set against any point that Mr. Kelly makes about constraint payments. The carbon smelter forms a useful grid role in itself. Mr. Bell, just you want to finish off the point?
Yes, just quickly on constraint payments. They are a well-established part of the overall national grid balancing approach to the UK network, and they're not new. They were consulted on the concepts consulted on many years ago and supported by the UK government. And furthermore, we get some help from SPP in paragraph 165, which sets out the grid capacity should not be used as a reason to constrain areas identified for wind farms or on decisions on individual applications. So there's very clear direction from the government. We're aware of this issue in the wider grid that is being addressed by the licensed grid companies, SSE and SPR, in terms of grid reinforcement works around Scotland. But it is not a material matter, in my view, given the national policy position to be taken into account and given any weight.
Thank you, sir. That's a response from the applicant.
Thank you, Mr. Trinick. I was going to ask Mr. Finlay if he had any points that he wanted to make before we we move on to the next matter.
Just three brief ones, subject to Mr. Heinsohn having anything to say. First is that there seems to be agreement that energy policy is a UK matter, but Ireland Council's view on it is that there's no inconsistency between UK energy policy and Scottish Government energy policy. The two are designed to be read together. And so that as far as THE is concerned, there's no conflict between the two. And so they're both, what weight is to be given to them is another matter about which we've made submissions, and indeed we're agreed with the applicant in many respects in the statement of agreed matters. That's all I wish to say about that, really no inconsistency. The second point I wish to raise was about need. And with respect to Mr. Kelly, planning and need can have a particular context. And where I differ from both other parties, then in our submission, need needs to be differentiated from strong policy support for a desired outcome. And what we have in this case is strong policy support for a desired outcome. And so that applicants don't have to demonstrate particular need in order to take advantage of that strong policy support. I agree with Mr. Bell in this respect that the Airy case, which is, I think, one of the more recent minister's decisions at 9.21, confirms that the guidance set out in the onshore wind policy statement is still current. And that will become relevant when we move on. But the reference to need in the paragraph to which he referred, which for your notice, electronic page 27 of 58, in the third full paragraph and fourth line, is reference to need in a very general sense. It's not in the particular planning sense that Mr. Kelly was referring to. There is a need for renewables in the broadest sense of the word, but that isn't going to lead, with respect to Mr. Kelly, to all hills being covered with wind turbines, provided the appropriate tests are carried out and that the environmental constraints are balanced against the strong policy support for the desired outcome. So that I don't think I wish to say anything on constraint payments or pipeline. Those are the two issues, and Mr. Heinsohn's indicating he has nothing he wishes to add to that.
Thank you, Mr. Finlay. I think that does take us on to the next sort of question, or the next bullet point C, in terms of the weight in the decision-making process in terms of the policy support that you've outlined. In particular, I was going to ask the applicant, in my reporting of energy policy and targets, is there any additional or change of weight with regard to either climate change or COVID-19 and recovery plans in recent times that has altered or should alter the balance of weight afforded by ministers when it comes to making decisions on Section 36 applications? Perhaps I could ask Mr. Trinick for the applicant to consider that matter first, and then I'll open that up.
Thanks. I'll hand over to Mr. Bell.
I think the answer on that is the reference to the very recent additional material considerations that have come into play. And what we'll be covering in some of the other items when we get on to, for example, SPP, is that SPP was prepared at a time of very different targets and policy imperative. And we also know that when the urgent need was set out in the onshore wind policy statement, that was at the end of 2017. Since then, we have had the Emissions Reduction Act 2019 and the new statutory targets to attain net zero well in advance of the UK position. and we've just had, that will come on to the CCC report, that gives advice to the Scottish Government on what should be in NPF4 on onshore wind. And of course, we don't have that yet. But all of these factors together, we are saying, are additional, very recent material considerations that go to the matter of weight to be given to the benefits. And to put it short, if it was urgent back in 2017, then it is more urgent now, given the position set out in these various documents.
Thank you, Mr. Bell. I mean, does the pandemic, I think that's been alluded to by some parties, provide additional weight, if you like, to be considered? Is that a very recent change that should be considered within a planning balance?
Yes, I mean, I have set out in my hearing statement the Committee on Climate Change response to the Scottish Government on a green recovery, CD 6.19. The specialist report from the Advisory Group on Economic Recovery to the Government was published in June 2020, that's CD 6.21. And more recently, the report of the Climate Emergency Response Group, July 2020, that's CD 6.25. The common theme in those documents is and this is a quote, the massive opportunity to catapult and prioritise progress to the net zero economy. So I think, as Mr. Blackett has highlighted earlier, there are some sectors of the economy that will be slow to recover. In particular, in Highland, tourism and hospitality will be one of those. But one of the sectors that can have a short-term impact with investment is the green sector, and we will be seeing that from the UK government shortly in their 10-point plan. And the clear advice to the Scottish Government has been that from these various groups. And we've also seen it set out in the programme for government set by the Scottish Government. And the anticipation is that we will also see that in the NPF4 position statement and the climate change plan to be published over the next few weeks. So I would say these very recent documents on the COVID impact are very relevant with specific regard to renewables and the contribution that they can make to recovery.
Thank you for that, Mr. Bell. I think just now, I think I would turn to Mr. Finlay, and just on any of these points, have you got anything to respond to?
Well, yes, and I acknowledge I may be slightly jumping ahead to further points, but it may make sense to deal with the point only once. If I can take you back to the area decision, which is CD 9.21, and Mr. Bell has referred to that because I think it's the most recent Minister's decision before you. It's March of this year. And there are other decisions before you, Hagshaw Hill, which is CD 916 in February 2020, Lime Kilns, which is June 2019, which is CD 9.9, and I think Tangy, which is CD 9.22, which use very similar language, but I'll just concentrate on the most recent one. The ministers deal with policy context at electronic page 13 of 58. And they deal with many of the matters that Mr. Bell deals with, but they don't, in that their consideration of the policy context, suggest that there is any change to the balancing exercise that you have to take into account. Because if you have additional weight on one side, it means correspondingly less weight on the other side. They look at MPF3 and make it clear that NPF3 is the spatial expression, i.e. currently is a spatial expression of the government's economic strategy. There is no suggestion that NPF3 is out of date, and it continues in that vein. Likewise, SPP, there's no suggestion that SPP is out of date in providing appropriate guidance in that regard. And in terms of the energy strategy, it confirms that the onshore wind policy statement reaffirms Scottish Government's position. I acknowledge that the COVID pandemic postdates that case in effect, but there's nothing in that case which suggests a change to the balancing process by increasing targets, which I would submit reinforces the point that I made earlier, that this is not a need case, because if there was a need case, it would depend on how much progress you were making towards the targets or otherwise. It's a case where there is a strong policy objective to provide increased renewable energy across a wide range of potential types of renewable energy, of which we acknowledge this development can take advantage of. But there's nothing in the weight which is to be afforded to that policy objective which has changed. And in that regard, I'd refer you to the Statement of Agreed Matters at paragraph 520, where parties are agreed that energy policy should be given significant weight. And that is the beginning and end in my submission of the submission. One has to be careful, Mr. Bell has to be careful of seeking to go beyond that agreed position. So I accept that I may have strayed into some subsequent questions, but in our view, the policy, the balancing exercise has not changed for the reasons I've just indicated, and there is no decision, minister's decision, which suggests otherwise.
Thank you, Mr. Finlay. I think you've probably started to answer item D. So I think I could pose that to the applicant in terms of, has the decision-making framework for ministers for Section 36 applications changed since SPP and MPF3 were produced back in 2014? Has the decision-making framework itself changed? I think Mr. Finlay was expressing his view on that there. So, Mr. Trinick.
Thanks. I'll let my witness speak. Mr. Bell.
Yes, thank you. Clearly, NPF. Sorry, I'm just getting rid of some of my screens. Clearly, NPF3 and SPP remain in place. And they're not yet altered. You may see that starting next month. There are these various other considerations, however, that have emerged since these documents were published back in 2014. We've referred to the Scottish Energy Strategy and the Onshore Wind Policy Statement. These were both of December 2017. And point I raised just earlier was that both of these documents did not take account of what may be required in terms of attaining net zero targets. And they also did not anticipate the Emissions Reduction Act 2019. It was quite clear, though, from the advice the Scottish Government got from the Committee on Climate Change, that the 2009 Climate Change Act was not sufficient. It was simply not good enough to go for 80% reduction by 2050. And the 29 Act has amended the 2009 Act that is referred to in SPP. So whilst Mr. Finlay is right that SPP remains the planning framework, the statutory framework that SPP refers to has fundamentally changed. And for every year now until 2045, there are targets set for emissions reduction. And we are way behind even what was set for 2018. So I think there is recognition that the lockdown this year will give rise to a big fall in emissions. But the Committee on Climate Change has said we're going to go right back on track once the recovery comes. And when I mean on track, I mean in terms of emissions rises. So the targets that are in SPP are very outdated, and they simply, the SPP does not capture, in my view, the sea change that is needed to attain net zero. Now, to assist matters, I have referred to a planning appeal decision called Millenderdale, which is CD 920. And in that case, the reporter placed greater weight on the benefits that would flow from a wind farm as a result of the considerably heightened importance of the need to respond to climate change. And I've referred to that in my hearing statement. So it's the weight to the benefits that we say is in the gift of the decision maker, and that can be done within the framework of the current SPP and NPF3. And if we just look ahead, the latest position is that the October 2020 report from the Committee on Climate Change, which is CD 6.31, gives a clear recommendation to the Scottish Government for NPF4. And that is, and the quote is, align the NPF4 to a net zero energy system by ensuring Scotland has a favourable planning and consenting regime for onshore wind and other renewables. So it's onshore wind that gets that specific reference. Now, of course, we do not have the NPF4 position statement. We may have it within a few weeks. Now, the key point I would finish on is to say that the policy imperative and the speed of response that is required is now clear through these recent material considerations. And certainly the Committee on Climate Change used the planning system as key to delivery of reduced emissions. And that brings a focus to bear on planning decisions and for decision makers to act on that. So hopefully that helps assist in terms of the matter of weight to go to the benefits and how we say that should be approached in the determination.
Mr. Finlay, do you have anything to add with regard to any changes to the decision-making framework for a Section 36 application since the production of SPP and NPF3, or have you already covered those matters?
Just a short response to Mr. Bell. The Millenderdale decision to which he refers is of a date with the ARI decision, and finds no support in any of the minister's decisions to which I've referred to earlier, which are contained in the bundle, i.e. that less weight should be given to the environment or more weight should be given to benefits than was previously the case, or that SPP or NPF3 are out of date. That is simply inconsistent with the consistent line that ministers have taken in their reports, the most recent one being ARI in CD 9.21. Secondly, Mr. Bell has said that there's been fundamental change in terms of the goals that are being set. It's no part of Highland Council's approach to suggest that there hasn't been significant change, whether one calls it transformational or fundamental, it matters not, in the background but there has been no change in the balancing exercise that has set out in planning policy or energy policy, and no suggestion in any of the policy documents or any document to which he's referred that less weight should be given to impact on the environment than had been given before. And there's no suggestion, as far as I'm aware, that NPF4 is going to change that position. So in our submission, whilst there have been significant changes in terms of the decision-making framework with which you are engaged in advising ministers on, there has always been, as the decision in ARI makes out, strong support for renewable energy. That remains the case, but it should only be in locations where it's acceptable.
Thank you, Mr. Finlay. I think I might actually ask, jump on to agenda item 3A, because it is linked in terms of the relevance of the timing of the review for this case. Does it have any implications? Do any parties feel that that any imminent or otherwise decisions about what's published on NPF or indeed SPP has any relevance for this case? Mr. Trinick, first off, perhaps.
Yes, I'll ask Mr. Bell to address that specifically, but I have a final point to make.
Yes, in terms of that question, I think these will be very relevant documents for you: the NPF4 position statement, and the updated climate change plan, because we do have, as I say, the specific advice from the Committee on Climate Change to the Scottish Government is that they should address a favourable planning regime for onshore wind in Scotland. It's the only technology that gets a mention in terms of planning policy change. And the climate change plan is the first one to deal with net zero and is expected to set out what is the generation requirement needed to attain net zero. Now, what we do know is that there needs to be what's termed deep electrification in society, covering transport, housing, various other sectors, and that will come from renewable sources. So we do expect to see a clear indication of what the generation targets will be to attain net zero. And that links to the pipeline point that was discussed earlier in the wider need case. So my view would be that if these documents come out in December, then certainly there should be the opportunity to make representations on them and for you to certainly properly understand any consequences for your right up to decision in due course.
So my final point is simply this, that put our case beyond doubt, if you can envisage a horizontal scale along which the planning balance tilts from time to time for or against a particular form of development. Our case is that that tilt point on the horizontal scale has, as a result of what has happened since SDP and NPF3, it has shifted so that it may be that it is necessary to accept a higher degree of impact development in order to achieve policy objectives. That maybe puts the point with some clarity. That is what we say, if that helps.
Thank you, Mr. Trinick. It does help my understanding of your position. Mr. Finlay, do you agree then with Mr. Bell's point that if these documents that he's referring to in terms of climate change plan and any NPF4 statement, if they were to be published or come out while I'm considering my report, that these are matters that are important that I get all the parties' views on?
So can I answer that question and ask Mr. Heinsohn to ask the question about the general relevancy review? If those documents raised a particular, suggested a change to the planning balance, then yes. But if they don't, then it's a matter for you whether you would need parties' input on them. Mr. Trinick has said that the tilt has shifted. You have in the core documents the Gladman decision, which is CD 924, which is a classic need case where there's a need to provide a certain level of housing. It's a housing case, no doubt you may be familiar, where indeed your president said the greater the need, the greater the tilt. But I've already indicated that this is not a case where there is not a classic need case as such, and there's no suggestion of a tilt, a greater tilt than that which is contained in either Highland Council Policy 67 or in SPP. But perhaps I can pass over to Mr. Heinsohn to respond to Mr. Bell if he wishes to add anything.
Yes, just briefly. Notwithstanding that over the past 6 years since SPP was published, there has been the wider changes in society. The climate change group has published their reports and their recommendations to ministers. The Scottish Government have clearly signalled that NPF4 will look very different to the existing NPF3 and SPP, not just because the documents will be combined documents, but because they'll be part of the development plan as well. But we don't feel that diminishes the continuing relevance of NPF3 and SPP as they currently stand. While Mr. Bell has mentioned that the targets have changed, the overarching policy framework in which the development requires to be assessed remains the same. So essentially, you could read SPP and NPF3 as they are just now, simply taking out those policy targets and putting those new policy targets in.
Sorry, Mr. Heinsohn, I lost your last few sentences there. I wouldn't mind if you repeated them for me.
Yes, no problem. I was just mentioning that what you could do in terms of SPP and NPF3. I appreciate that the references in those documents towards targets are out of date. However, the targets that Mr.
Sorry to interrupt again. I'm going to suggest that perhaps Mr. Finley's mic is causing some interference. So if Mr. Finley could mute, there we go. And I will ask you again, Mr. Heinsohn, sorry about that, to repeat that. I was just getting some feedback.
Third time lucky. Yeah, so I was just setting out that you've got NPF3 and SPP just now, and while the targets within them are dated, those targets could effectively be replaced with the targets that have subsequently been published by the Scottish Government, and the ones that have been referred to by Mr. Bell this afternoon and are set out in evidence. And there's no disagreement between the parties of the relevance of those targets.
Okay, thank you for that. I think that's probably covered that point A. I'm not forgetting agenda item 2E, but I might come back to that because I want to just ask one last question before we break, and that's item 3B. I was going to ask the applicant's view on what the council has said in their hearing statement at 4.3.6, which I've set out there in item B. So do you have a view on that from the applicant, Mr. Trinick?
So hand over to Mr. Bell.
Yes, just I think the council will clearly speak in a moment, so we can get clarity on what they mean by that, but in their hearing statement. But my take on it was that yes, the Scottish Government has issued a consultation on planning policy and housing, and that's a knee-jerk reaction, we all know, to the Gladman judgment. And there's been various representations made by wider industry on that. Now, the Scottish Government was sensitive to that and issued a Chief Planner letter in September, CD 4.14, because the suggestion of the wholesale removal of the presumption in favour of development could be read as less support for sustainable development in Scotland at a time of a climate emergency, which just makes no sense. Now, the government has made it very clear in that Chief Planner letter that it does not, the consultation, contradict any stated commitment of ministers to renewable energy projects and their delivery. So I think we will no doubt be agreed on that. And there are one or two other, there's another point in your item B on substantive change of approach to SPP. I mean, to reiterate, we are not saying that there is a substantive change of approach that needs to be made to SPP. The point that we've said is that it's the way to go to the benefits that can legitimately change in light of material considerations, not that we need to take a different approach to what is set out in SPP in terms of the planning framework.
Thank you, Mr. Bell. Mr. Finlay, is there anything additional that you need to add, having heard Mr. Bell's response on item 3B and your statement in the hearing statement?
I'll ask Mr. Heinsohn if he wishes to add anything.
Just briefly, what we were trying to get across in terms of the point within our hearing statement was that we were referring to the Gladman case, and that Scottish Government have taken the opportunity to undertake a consultation on potential changes to SPP as a result of that. We were simply highlighting that the Scottish Government, that it was very rare for them to do so, and they haven't done so in relation to the climate emergency that has been declared by Scottish Government and also by Highland Council. What we were looking to is that the Scottish Government's, the more formal Scottish Government statements on matters related to climate change have indicated the need for the systematic response, which was the set out in the Climate Change Secretary's statement, which is in Core Document 6.28, which also reflects the view of the Climate Change Committee in 2019, which set out the need for clear, stable and well-designed policies. And then again, the Climate Change Committee in 2020's view that strong policies from across government are needed to reduce our vulnerability and the destructive risks of climate change and to avoid the disorderly transition to net zero. So essentially we were putting out the point that Scottish Government haven't just taken that knee-jerk reaction as they did with the Gladman case. They are taking that more systematic response in relation to policy.
Thank you, Mr. Hinson, for explaining that just that little bit more. Mr. Trinick.
So, Mr. Bell, would like to come on?
Just very, very briefly on that. I think the Scottish Government's always been very clear that NPF4 will be key to the delivery of net zero, but they've needed the climate change plan to come out first and for NPF4 to facilitate the delivery of net zero. So on the Gladman narrow point, the government can run a consultation, but that doesn't mean that they've taken their eye off the ball on renewable energy. They've always said that it will be tied in with net zero, and the programme for that was meant to be in April this year, but the Committee on Climate Change has said that they welcomed the delay because of the pandemic to the delivery of the climate change plan in December. And that is where we will see how NPF4 will link to it. So I think that is the explanation, rather than a suggestion that they simply don't see it as a priority. And that's why they haven't said anything on it.
Okay, thank you very much for that. Dr. Gordon or Mr. Kelly, do you have anything to say on the matters you've heard since the last time you've spoken before we break? Was there anything burning that you wish to say? Mr. Kelly?
Thank you, sir. Just to support what Mr. Finlay said, there's been no indication from Scottish ministers of any downgrading of environmental or landscape protection in their decision making. That was all. Thank you, sir.
Okay, I plan to return then at, Mr. Trinick.
So just one point. Looking ahead at the agenda, it would be helpful if we took nothing else later on, but 5B could be taken today, and that is the new 5B about the background of wildland areas in Jake's Abbey, because Mr. Welch is going to come on for that part of the call, and he can't be here tomorrow.
I didn't catch all of that, but I think it's in relation to wildland item B being taken today, because you've got Mr. Welch available. Any other party got any concerns about that? No.
Looking around the room, no, not as far as
Okay.
I'm aware. It seems to me we should have time to finish 2 and 3 and then hopefully deal with wildland, but certainly 5B. If we can deal with wildland today, so much the better, because that allows Catherine and Harry not to attend tomorrow either as well.
Well, I'll bear those comments in mind to see if we can complete 2, 3 and wildland, and that could be our target for this afternoon. So, okay, I'll see you back at 3:15. I'm sorry, Mr. Kelly, that doesn't give much of a break, but I'm just conscious that we probably want to be finished not long after 4. So back at 3:15, thank you. Well, that's us at 3:15, but I'm not quite seeing everyone back. But I do see Mr. Trinick on his way. Okay, I think we'll make a start to the last session of the afternoon. Quickly on item 2E, and this may just be a question directly to Mr. Kelly, with regard to paragraph 24 of your hearing statement. Is there any additional legal decisions that have not been submitted that should be submitted? It was just a straightforward question. I don't think it's necessarily a matter of dispute, but I'm just taking the opportunity to ask, was there additional decisions on what is material planning consideration that you wanted me to consider? Mr. Kelly.
The short answer is no, sir. More generally, can I just say, while I have your attention here, that because I would be grateful for a 4 o'clock sharp finish today, I have no objection whatsoever from my part if you want to take the wildland point as the first substantive item this afternoon beyond that, but I'm entirely in your hands. But in terms of that point, the answer is no further cases.
Thank you, Mr. Kelly. Do any other parties have any concerns if I then went on to the item with regard to wildland, just in case we got onto a longer discussion? That seems fair. Mr. Finlay, thumbs up. Thumbs up from Dr. Gordon, and Mr. Trinick, thumbs up also. Good. So what we'll do is we will jump onto item 5 on the agenda. And what I will do, as I said, I didn't muck about with the ordering, but I will take item B first, 5B first, with regard to the background to wildland areas, including the Jenks mapping, because that came up in the inquiry, and it also had been previously raised, I think, by Nature Scott to include it in the agenda, and obviously I responded to that at the time. So my opening question to Mr. Finlay or his representative from Nature Scott is, when we do have the wildland areas set out and the description of their special qualities, together with the guidance that we've referred to in the inquiry sessions on assessing the impacts, that's the new 2020 guidance. Explain to me why the background and the Jenks mapping is important to this case.
I'll ask Ms. Harry to respond to that in detail, but in essence, our case is that it isn't important. We only wish to raise it as an issue in order to have the best people explain the context to which Dr. Carver and Mr. Welsh were making their comments. It forms no part of our case, but it's important. In fact, our case is that with the documents that you've just indicated, there is no need to have regard to the background mapping. But perhaps I can just ask Ms. Harry to come in here to explain why that is so, and to assist you in that regard.
So, as Mr. Finlay has explained, that the mapping has no formal status in policy. It's very much a means to an end, so to speak. So it was part of the workings that we used to identify the wildland areas. It was part of the process. And we know that phase 1 of the mapping, which was explained in some detail in Dr. Carver's evidence, last week was again part of that first phase of the massive mapping process. So we use this second phase, the Jenks mapping that has been talked about extensively, in order to interpret those maps and the methodology, because the mapping required us, as Scottish Government did, to identify wildland areas, not that continuum of wildness. So as the second phase, we use this statistical tool, which is what it is, to enable us to interrogate this huge data set of information that was presented across the whole of Scotland, to be used in a very transparent and repeatable and objective way. So it did avoid the use of an arbitrary threshold, so to speak, to help us in going further to identify those largest areas of highest wildness, which is what wildland areas seek to do. So once we had applied this statistical tool with the aid of our GIS analysts, we were then able to go on to the third phase of the mapping, which was to consider actually identifying areas. And rather than, I think it was been referred to twice in evidence about a Sharpie round the map, there was far more of a process that went on with regards to professional judgment in that. So all of that detail is within our methodology, which is CD 5.37. That non-technical methodology takes you through carefully those steps of the 3 stages of the mapping process. But I think what's important here as well to just highlight is that there was quite a lot of talk about limitations of the mapping, both in Miss Anderson's and Mr. Welsh's cross-examination. So we went through quite a few of those limitations, and actually Dr. Carver's as well. And I just want to emphasize that the very nature of a data-driven analyst is that there will be some limitations. That's its very nature. These aren't errors, and they are addressed by us through the third phase of that mapping process, i.e. we were able to look at some of the solutions to those. So we have identified that this is the wildland areas are a strategic mapping tool, and I think that's the key phrase that we refer to in our advice to government, which is CD 5.23, particularly at electronic page 17, paragraph 5.2. Where it states, we consider that the map can be used most effectively as a strategic planning tool. So that phrase has again been repeated in other documents, and we heard it through evidence as well throughout last week. So it's not about the phrase to mapping that we put emphasis. That mapping is very much a means to an end. It's about the identification of the wildland areas.
Thank you for that. Mr. Trinick, do you align yourself to the comments of Mr. Finlay, or have you got additional commentary to make on either what Mr. Finlay has said or Ms. Harry has said?
I'm going to ask Mr. Welch, who I see is on the call, to respond to that.
You better unmute yourself, Mr. Welch. Thank you.
Good afternoon, sir. I should be learning by now. Thank you. I do share much of what Ms. Harry has said about the map being a strategic mapping tool. The only area I would differ in is that I think it is helpful to look behind the boundaries of the wildland areas and gain an understanding of the relative sensitivity of different parts of the wildland area. And the Jenks mapping is very helpful in giving us that background to the WLA. And I've included it in 2 of my figures, JW 16 and 22. And I think they help to help us when we undertake an assessment of the likely effects. And as I say, that's primarily by giving us some sense of how sensitivity might vary across the wildland area. So that's probably one area where I find the Jenks mapping and looking back at the historic mapping of attributes to be useful. And it is a direct reflection of the 4 layers of attributes that were mapped in 2014. So it traces that mapping history, if you like, that ultimately led to the wildland area boundaries in phase 3. But I support the documents that Ms. Harry has drawn to your attention as being the relevant ones.
Thank you, Mr. Welch. Mr. Kelly, do you have any points on what you've just heard?
So just one, if I may put the question through yourself. During Dr. Carver's evidence, reference was made to his battle being with SNH, Nature Scott, in terms of the repeating of the mapping. Having regard to that and to help you understand that line of cross-examination and the answers, I would ask Ms. Harry if she could explain why, given that the methodology, the mapping methodology was specifically required to be repeatable, SNH and Nature Scott have not sought to remap the wildland areas when these very large wind farm proposals come along. That's the sole point, sir.
Mr. Finlay, do you wish to make any remarks before asking Ms. Harry whether she could answer that?
No, I was going to ask Ms. Harry to answer both Mr. Welsh's point and Mr. Kelly's point.
Thank you.
So if I just go to Mr. Kelly's point first, that whilst any kind of sound methodology is useful to be repeatable because of the data sets underlying it were publicly accessible. This is useful to interrogate the data for others to do that. It was never our intention to repeat this mapping. We were undertaking the mapping under advice and under a request from Scottish Government to identify wildland areas, and should that need or request be repeated, then of course we would look to undertake that again. But to undertake the mapping in response to each specific development change is quite an undertaking. Some of the mapping, including, I think, as Dr. Carver identified, requires some not off-the-shelf software. It's quite resource intensive because it requires to be run through across the whole of Scotland. It's a relative mapping process. You can't identify a small area and remap that. The second point, which is I'm just going to respond to something that Mr. Welsh identified about relative sensitivity and the usefulness of the Jenks mapping in looking at whether it's individual applications or just more generally interrogating the data. So I would agree that looking back, not just from the wildland area mapping, as in the identification of the areas, some of that underlying data is important to refer to, as indeed we do reference mapping, albeit we don't specify which mapping in our assessment guidance, which is CD 5.38, and I think it was a specific reference that we've taken to before, so it's paragraph 18. I'm sorry, I don't have the electronic page number, but it's a short document, that one. So there is reference to mapping work there, so it is a useful part of the process. But we can use those, the mapping. We have to be a little bit careful when we do that. And if it's helpful for you to look at an example, I think the JW22, which Mr. Welsh was just referring to, which is CD 12.3II. So that was the applicant's Jenks mapping, which is helpful because it identifies the wildland area. So this map does look across and includes the kind of range of colours, which is your range of Jenks mapping zones which is really useful. So those classes are identified, and we can see that there's a majority of the, as you would expect, the higher top 4 classes, which is pink, orange, green, and red. But there's also areas of lower classes, as you might expect, in the lower ground, so within the glens, with the higher classes being on the hilltops. But we know that by undertaking fieldwork to understand the data sets behind this, we can see some of those nuances and the differences in mapping coming out. So, for example, we know that tracks are given a standard score. We know that distance, yes, there's a distance decay from certain artifacts, but if there is an artifact mapped, such as a bothy, that will be identified as a very low score. So the influence of this mapping, it varies hugely, and we just have to be a little bit cautious, I think, about how it's represented on the map. We don't have the 4 layers, sorry, submitted to the inquiry, but if we were to look at those 4 layers, you'd be able to see which ones have the greatest, perhaps, influence. So for example, naturalness is reasonably high across the whole of the wildland area, which probably won't be surprising. Ruggedness in parts is relatively low, particularly through the glens, as we've talked about. And remoteness is again lower within those glens because of the influence of the track, and previous evidence given last week was identifying why that was the case. So there's some differences between the parties about how heavily that influence that track is on your sense of remoteness, and I think that's again for yourself to take a decision on, or take a view on. And again, the lack of built artifacts, the mechanistic approach that the GIS mapping undertakes needs to be looked in the field as to how that is actually understood. So we know that wind farms, for example, are given a score, so they're excluded from wildland areas, and there is a distance decay added to the mapping. So the further away you are, in very simple terms, the effect it has will lessen. But we know, by having looked at this data, that actually that distance decay drops very quickly, and what it doesn't do, the mapping, is it doesn't identify the effect. It's a visual representation. This is just a lack of built artifacts, is a viewshed mapping tool, but it doesn't identify the effects on your experience. So we've been clear that those things are very separate, and that's why it's important to use mapping in the context of on-site analysis.
Thank you very much for that explanation. Mr. Trunick, do you wish to add anything else before I come to Mr. Kelly to wrap this point up?
Only on this, that in looking at CD 538 page 5, which sets out the steps you take to assess the impact of a development on wildland qualities. I just want to understand, I'm not making an argument here, it's probably a safe proposition, so Catherine and Harry can tell me I'm right or wrong, I don't know, which is that someone in Mr. Marshall's position, or Nick Carolance's position, when undertaking step 2, the verification of the WLA baseline, would clearly undertake on field work, and the purpose, one of the purposes would be to see, as it says in step 2, what changes have occurred since the description was prepared. So my understanding is you go out in the field and you verify the degree to which the attributes are expressed and what changes may have occurred. You then apply the perceptual quality, the perception of attribute layer, in order to come to a view on the strength of the wildland qualities set out in a particular area, and then you can proceed to step 3. It just occurs to me, and I suppose it's a question through you, sir, to Ms. Harry, is the extent to which, in undertaking that verification, it would seem useful to go back to the original wildland GENIX class layers and to see the degree to which those attributes are still expressed. Have I got it entirely wrong?
Mr. Finlay, perhaps Ms. Harry could respond to that, and also maybe if there is anything further with regard to why that step hasn't been put into the guidance, then Ms. Harry could explain that also.
Over to Ms. Harry.
Yeah, I think it's a good question because, and it's something that we have considered in mine and others, including Mr. Welch's extensive experience in having to work through proposals in the light of the emerging guidance and the mapping over the last 6 years or so. We found that actually the underlaying wildness maps, so that the 4 layers of the maps that we've been taken through have been very useful in better understanding the baseline situation along with being out in the field. I would say less so the Jenks mapping. It's almost too it is helpful and informative and interesting, but I think it served a purpose that we're finding that in really understanding the qualities as they've been described in the descriptions, actually, you know, there's quite a big step between the Jenks mapping and the qualities as described, and those two things don't always match up. And an example would be Sanderson's evidence on you know the heart of the wildland area, as opposed to how well expressed those qualities might be. And I think that's probably a useful example to refer to. Why? Well, and that's the same answer perhaps as to why it hasn't been included in the guidance, because we felt that yes, reference to the mapping can be useful. Its purpose was certainly not to aid the assessment of effects on wildland, because it can't do that. Only we believe, you know, an assessor with a good sound understanding of those wildland qualities and the effects that are likely to occur with the individual development can do that.
Okay, thank you. I'll perhaps give Mr. Trinick or Mr. Welch an opportunity to respond to anything there before I bring Mr. Kelly in.
Thank you, sir. I agree with Miss Harry insofar as ultimately this comes down to a site assessment, and that is what is the most important part of the assessment process. But nonetheless, I think this gives a useful starting point and sense of direction to that study by understanding how and why the wildland area is shaped the way it is.
Okay, thank you for that. Mr. Kelly, anything additional to add?
Interestingly, I find myself agreeing with the very last point that Mr. Welsh made about the usefulness of the mapping. More generally, I think the comments from Ms. Harry go to the heart of the subjective versus objective approach that we discussed last week. And it might have been useful to have had evidence from Nature Scott at that stage. There's one thing she said, which unfortunately I have to check on with Dr. Carver and deal with it in closing submissions. She said that the remapping was only ever envisaged if they had been asked by Scottish ministers to remap. I don't think that's Dr. Carver's understanding from his original involvement in the methodology, but I'll need to check with him. He's not available this afternoon, so I will check with him. So beyond that clarification, sir, I have nothing further to add at this stage.
Thank you, Mr. Kelly. It may well be that I, in my report, and this particular case is not the area for that debate. But if you do make representations in your further submissions, I'll certainly look through them. Item 5A, which actually moves away from the background mapping into what the planning policy, the national planning policy, says with regard to wildland. I just want to make double sure that there's the potential that we're on the same page on this in terms of which paragraphs and which references are appropriate for this application with regard to a wind farm which is located out with a wildland area. So if you're looking at SPP, I think it's on page 44 in terms of paragraph 69. But the applicant, first of all, and it may well be for Mr. Bell, just clarify your understanding of the applicability of these different paragraphs and what I should be advising ministers with regard to the policies I have to take into account in SPP with regard to wildland areas.
Thanks, sir. I'll deal with it very quickly. This one, certainly 169 is relevant. That's absolutely clear as a consideration listed within paragraph 169. Paragraph 200 we don't think is relevant for two reasons. Firstly, because it's advice on development plan making rather than development management. Secondly, because the wording of paragraph 200 makes clear in terms of the words have little or no capacity to accept development. It's about development within wildland areas. And thirdly, SPP 215 is irrelevant because that quite clearly relates to development within wildland areas. So a fairly straightforward position, and that's it.
Mr. Finlay.
In general terms, I agree, just with one small caveat, which is to really repeat a point that the Limekilns report has made, which is that the identification in para 215 of the qualities of wildland areas simply gives an indication, albeit that is concerned with development within wildland areas, the type of factor you should have regard to outside wildland areas. I don't think that's in dispute that you have regard to the wildland qualities outside the wildland areas.
If it helps, sir, I agree with that. Perfectly happy.
Mr. Kelly, are you in agreement with what we have heard?
Yes, sir. In a strict literal sense, paragraph 215 doesn't apply because the wind farm is not within the area of wildland as mapped. But as indicated, the reference to the qualities as picked up by the Limekiln reporters gives you a flavour of what might be expected from paragraph 200 in terms of development planning, which aims to identify and safeguard the character of these areas. And that in turn leads you back to how you might approach the concept of significant protection. Significant protection is obviously protection from harm. And I think it's perfectly obvious that that harm, and indeed variable degrees of harm, can arise from developments both within and out with the wind farm areas. So generally, I'm agreeing with what is being said, maybe a very slightly different nuance that paragraph 215 gives you a flavour that you should apply to the other paragraphs.
Mr. Trinick. Yes.
Well, not quite, because the test in 215, which is also the test in SPP Table 1, only applies to development within the areas. You can't transpose that test on some buffer zone approach to development outside the area. It doesn't apply, full stop. So that SPP 215 test is not applicable. I agree with what Mr. Finlay made. Mr. Kelly took it a stage too far.
Thank you, Mr. Trinick. Now, I think that's possibly all that I have to ask on wildland policy matters per se. Before we move off agenda item 5, is there any burning questions with regard to wildland policy that you thought should have been addressed under this item? Mr. Finlay's shaking his head, so that's a no. A shake of the head from Mr. Trinick, that's a no, and Mr. Kelly's shaking his head as well. Excellent. Well, we'll make a trip back to item 3, And we were at 3C, I think. So that takes us neatly into SPP once again. So just since we had almost agreement there, I'm just wondering if there's agreement that it's paragraphs 28 and 29 with regard to the presumption in favour of development that contributes to sustainable development. Is there agreement that it is 28 and 29 that I look at? I know that in the statement of agreed matters, I think paragraphs 32 and 33 are mentioned, but are the main paragraphs the 28 and 29? Mr. Trinick.
Perhaps if I jump in first, yes, I think Mr. Bell makes the point that because we are in a section 36 Electricity Act case, the primacy of the development plan doesn't apply. So therefore paragraphs 32 and 33 are background and not of direct application. So that the presumption in favour of development that contributes to sustainable development applies with as much force as it ever did. It depends upon the finding that the development is sustainable. But yes.
Mr. Trinick, are you or Mr. Bell in agreement with what Mr. Finlay has just said?
Please agreement, it's 28, 29, yes.
Okay, that's straightforward. Which leads me to my next question under that is a wind farm inherently a development that contributes to sustainable development, or does it need to be an environmentally acceptable wind farm? Just in terms of my consideration of those paragraphs, is a wind farm inherently a development that contributes to sustainable development, or does it have to be an acceptable environmental terms wind farm? And I think I'll ask that of the applicant in the first instance.
The latter, sir, it has to be environmentally acceptable. There's no such thing as inherent sustainability for a wind farm.
And we agree with that.
And Mr. Kelly, you don't have any issue?
No, fully agree with that.
Yeah. Point D now then, with regard to how you treat a site that may have a group 2 interest in terms of SPP's table in paragraphs 61 to 66. How best to consider a site that may have a group 2 interest if other parts of the site are group 3. We may have that situation in this site, on this site. How best are we to regard a site if that group 2 interest is satisfactorily addressed, if ministers considered that there were no impacts on carbon-rich soils and peatlands? Does that mean that I should be treating it as a group 3 area, Mr. Trinick?
Well, so perhaps I may assist if I help us. We think you should, and I doubt Mr. Trinick's going to argue with that. There have been a number of other cases where the group 2 considerations have been found acceptable or have been dealt with, particularly carbon issues, and quite often that is mitigated by reason of the particular siting and design of the turbines or the tracks. So we're content that you would treat it as if it was in a group 3 area for landscape and visual and other matters, and for your general approach.
Mr. Kelly, do you have anything to add to that?
No, I would agree with that approach.
And I guess Mr. Trinick is going to agree, but I'll let Mr. Trinick speak.
Yes, we do. I think it's now well established, that particular point, as articulated by Mr. Finlay, and nothing to add.
Thank you very much for that. We can move on then to item E. If this is SPP paragraph 169, which sets out a list of considerations for such developments. I just want to be clear that are these tests, if one consideration is considered to be unacceptable, does that mean the proposal is contrary to SPP, or do you need to have a balancing exercise? I think we touched upon that in the inquiry sessions with regard to visual impact, but those considerations in paragraph 169, if one is not considered acceptable, do you still need to look at the balance in the round? Mr. Finlay.
May I assist if I come in first? You have to look at all the considerations. They're not tests, and it's the balance in the round. And the same answer goes in due course for Highlands Policy 67. They're not tests. They're factors you have to take into account. You have to take them all into account. The extent to which one factor may be, there's friction with one factor may or may not determine the outcome. So one factor could be decisive, or it may be a combination of factors.
So from that, Mr. Finlay, if a development was considered to be unacceptable on visual terms, that still needs to be put into the planning balance. That's what you're saying.
Yes, and come back to the acceptability in visual terms, but if one was to say, follow Mr. Welsh's line for sake of argument, that it was acceptable or unacceptable in visual terms, so you reach that conclusion, you could still find it acceptable overall as a result of applying the balance. Perhaps we should call it the Electricity Act balance because we're in the electricity world, but I completely understand the point you made.
Yes. Thank you, Mr. Finlay. Mr. Trinning, are you going to tilt that balance in any direction?
Well, these are, as you said, these are not tests. They are just factors to take into account. So you can't say you can fail a test under SPP 169 because it isn't a test. You look at the factor and you assess landscape, landscape and visual effects of the development. I agree with Mr. Finlay, you look at all the factors that are as relevant to the case. But I also know that the list of factors is inclusive, not exclusive. It says are likely to include. There may be others, I haven't found any others today, there may be others. But the considerations, I think quite simply, you take into account what's relevant. It's simple as that.
Thank you, Mr. Trinnick. Mr. Kelly, do you have anything to add before I move on?
Nothing further to add, sir.
Just going to check, Dr. Gordon, although you said you didn't want to contribute, is there anything in particular that you wanted to comment on?
No, sir, thank you. I was very tempted to just add to the unanimity. It is so pleasant.
Thank you, Mr. Gordon, Dr. Gordon. The final point, no, it's not quite the final point. Item F is with regard to paragraph 170, which has been referred to, and just clarify for this case what you consider to be the implications of paragraph 170, which indicates that wind farms should be suitable for use in perpetuity. Mr. Finlay, I wondered if you were going to stick up your hand and seek agreement.
This may not be capable of such a succinct answer, and I'm going to ask Mr. Heinsohn to give you his view, but hopefully it will be agreed with.
Okay, so our understanding of paragraph 170 is that it reflects the Scottish Government's web guidance, CD 4.13 of the onshore wind, some questions answered. In practice, that means that even though the consent may be time limited, the use of the site for a wind farm should be considered for all intents and purposes to be a permanent one. The implication of this is that operational effects should be considered permanent, and the magnitude should not be diminished on the basis that the specific proposal will be subject to a time limited consent.
Thank you for that succinct answer, Mr. Trinnick.
Mr. Bell, please.
Yes, paragraph 170 in SPP goes on to say that wind farms should be sited and designed to ensure impacts are minimised and to protect an acceptable level of amenity for communities. And in my experience, that's always been the approach that has been taken, that the fact that development may be time limited, usually for 25 years, in this case it's 30 years, is not a matter that justifies acceptability in relation to amenity, i.e. only because the development would be time limited is amenity acceptable. So that is not a new principle, and it's always been set out in Circular 498. It's set out in Circular 498. That time limit can never, or temporary permission, can never justify the reason for granting permission in relation to the effect and amenity of an area. And what I would add to that is that that's a different matter to reversibility, which is sometimes referred to. And this development, whether it's in place for 50 or 100 years, will remain a reversible form of development, distinct from many other types of development. So that is a material matter. If it wasn't, then we would not have a condition requiring the dismantling of the scheme and restoration of the site. I think another point supporting paragraph 170 and helping understand it is that the perpetuity point ensures also that a recognition that the targets are long-term and that the wind energy developments will play a role in supporting the sustainability of these targets as we go forward, so that the capacity of renewable generation doesn't fall away over time.
Thank you for that. Mr. Kelly, do you have anything with regard to that question?
No, sir, I have nothing to add to what's been said.
Okay. I'm quite happy to move on to item G, which is the last matter, and that relates specifically, Mr. Kelly, to a statement in paragraph 11 of your hearing statement with regard to the consideration of alternative. I was just wondering if you could expand on what is meant in that paragraph with regard to consideration of alternatives, and is that an important issue in this case, Mr. Kelly?
I think it is an important issue in this case, sir. I don't think anyone is challenging or disputing the concept that the smelter and everything associated with the smelter is important for Lochaber, maybe even important at a Scottish economic level. However, our position is that there would be significant environmental harm arising from this proposed wind farm. And therefore, the question of alternatives becomes important. And that is, in our view, there needs to be a much fuller exploration of the alternative means of the applicant achieving their business objectives to support Lochaber with less environmental harm. And it's quite a simple point, but that's it. We do not dispute the importance of the Lochaber smelter, but is this the only way? Is this the best way? Is this the least environmentally damaging way of securing its business objectives?
And are there cases that you can point to that approach has been taken for Section 36 applications?
The consideration of alternatives tends to be relatively weak in Section 36 applications. You have reference to generic searches for sites and the testing of sites against the alternatives, or reference to the alternatives of doing nothing. But in the specific circumstances of this case, we think that the consideration of alternatives is important. and there should be this exploration as to whether there are other means, less environmentally harmful means, of achieving the applicant's business objectives.
Mr. Finlay, does the council consider that to be a consideration of material matter for ministers?
Not quite in the way Mr. Kelly put it. There is no need for the applicants to consider or to demonstrate that they have considered and ruled out alternatives. The fundamental question for ministers is whether this site is appropriate or inappropriate in the balancing exercise they take. So that there may be other sites which might be more appropriate, it is neither here nor there. The point that Mr. Kelly makes, I would put a slightly different way, that the extent to which the applicants can suggest that weight be put on their broader case of power supply may depend upon the extent to which that they demonstrate they've explored alternatives. It's not to do with, there's no onus on them to do that, but the existence of alternative arrangements to supply power, of which there are, but which come at a cost, is a relevant material consideration. What weight you give to that will depend upon the extent and nature of the evidence that has been on those subjects. So I put it in that limited way, which is probably not too dissimilar to Mr. Kelly, but without prejudice to my first point, which is that in general terms, there's no need for applicants to demonstrate that they've ruled out other alternative locations.
Thank you, Mr. Finlay. Mr. Trinick.
I think alternatives in a planning sense, planning is relevant here, but it is relevant, has to be considered quite separately from EIA alternatives. There is a statutory requirement under EIA regulations to examine alternatives, but I'm talking here in a planning context. And there was a whole run of case law starting with the Trust House 40 case back in the 80s, which lays down very clearly in the planning sense, at least one test is that alternatives can only become relevant where there may be environmental damage as a result of development and where a limited number of permissions may be granted. So an obvious example where alternatives become relevant was the old Addington retail stores, where there was a battle royal usually which site. That's not the case with WIN because there isn't a limit on the number of permissions which may be granted. So I agree with Mr. Finlay, this is a matter of law. Planning alternatives are not in play here, as opposed to EIA studies of alternatives. In terms of that applies to alternative sites and it applies to alternative solutions as well. In other words, we don't have to look at alternatives to wind farms generally, nor to the Glenshire site. In terms of the PPA point, well, that's entirely separate. That's not about sites and solutions. We've already answered that point very clearly, and I've heard no evidence from anybody to counter what we've said, which is that the reason we're pursuing the Glenshire site is in part, and this relates to national benefits, because of the ability to secure a long-term 25-year PPA at a cost which assists Carver and other sites to survive and prosper, and which gives predictability in terms of the very important development costs due to having to use energy. So we've answered that point already, and we dealt with it this morning. I think there's anything else to add, sir.
Thank you very much, Mr. Trinick. I'm noting it's 4:05, and I think we've come to the end of that item. We still have a few items to go, so I'm going to propose that we stop for the day, and we deal with the remaining items tomorrow on national parks and the development plan, which is I think item 4 and 6. I'm pretty confident that we'll be able to deal with that in the morning between maybe 10 and 1 and deal with conditions thereafter. Is there any concern about that plan? I'm not going to suggest that we start any earlier because I think we've made good progress. Mr. Trunick, are you quite happy at 10 o'clock start and we deal with these two matters first?
So I am going to suggest we do start at 9:30 if that's okay, because I think we do need to make reasonably rapid progress. I don't think the National Park, we can be wrong, I don't think the National Park item will take us anything like the length of time that some of the items will take us. I don't think the development plan will take us very long at all. So I hope we will get on conditions on a 9:30 start by 11:30. That would be, I think that's entirely doable.
So can I say that I, in the spirit of agreement that Dr. Gordon noticed has broken out, complete agreement with my friend Mr. Trunick, if both as to the 9:30 start and the hope that with a fair wind we could deal with everything by lunchtime, albeit potentially a slightly delayed lunch.
Mr. Kelly?
Happy with the 9:30 start. I don't think the two substantive items remaining on your hearing agenda will take particularly long.
And Dr. Gordon?
Yes, I agree as well, sir.
Okay, well, I'm hearing what you've said with regard to what we should try and achieve tomorrow and tomorrow morning in particular, and let's hope we manage to get through all the agenda items and conditions as soon as possible tomorrow. That's not to say I don't have a few questions on conditions. So that said, I will say good night to you all just now. We'll see most of you tomorrow, and that will be at 9:30. Okay, good night.